Yes.
With your lordship's kind.
The motion is concerned well in the monthly list.
Sir,
But I'm paying only for
Sir, original sir, original.
Sorry,
I'm paying for mentioning some applets.
appellate side, not today.
The original side matter 95 to 98. This batch matter I mentioned last week for extension, my lord. My lord, may I come back at 2 p.m. My lord, today interim order is expiring. May I come back at 2 with notice to the other side? Last week also I mentioned. My lord,
Notice to the other side.
yes.
My lord, I want to mention one item, my lord.
May I be permitted to mention, when I'm mentioning for upgradation, it is running as item number 71 in today's list. But if it can be taken up today, my lord, there's a reconstruction plan that is beyond that they are constructing.
Give you a slip, not possible. Yes.
My lord, I may be permitted to mention one item, my lord.
Just a minute, madam. Just a minute.
My lord.
I have your lordship's kind indulgence, my lord. On the last occasion, I mentioned before your lordship, and my lord was pleased to leave the matter today. It's the appearing item number 46 in your lordship. But my lord, there is some urgency because, my lord, what happened? My property, the private
Take your chances. Take your chances.
46, my lord, I apprehend if
My lord,
Who knows?
by Mr. Sharma.
my lord, the only difficulty, my lord, the construction is going on illegally
Let it
on
go
my
on.
property.
Let it go on, sir. Anything which goes on illegally will be ultimately demolished. If it's illegal, it will be demolished.
My lord, the
Take your
corporation-
chances.
Corporation has mutated third person's name in my property.
Whatever the corporation has done illegally, they'll undo it. Take your chances. Item 46.
In the event, my lord, it doesn't reach, my lord. It is my humble submission.
Even it doesn't reach, it will come some other day. That's all it can be done. Yes.
May I have your lordship?
Should I hand over the slip?
Give the slip.
May I have your lordship kindly to mention one motion, urgent motion. I'm mentioning upon notice, original side matter. Your lordship, I wanted to obtain leave from your lordship to file on urgent basis last Thursday, on Tuesday, your lordship said to file the matter and give the number to your lordship.
Your slip, we'll see.
Now, the urgency, your lordship, is an order, the annual valuation which has been sought to be revised by the municipal commissioner and not the hearing officer. Now, the problem is municipal commissioner wrongly assumed jurisdiction. The appeal lies from an order passed by the hearing officer, not the municipal commissioner. They have
The judgment which I have also passed that the municipal commissioner is empowered to pass an order.
yes, but first that is municipal commissioner subject to lordship's correction. Municipal commissioner has the power to amend the book after the proceeding done by the hearing officer.
So these are all delegated powers which can be done.
There's a
I don't know
judgment-
about your case, but
There's a judgment of our Honorable High Court that once I raise an objection, that matter has to be heard by the hearing officer.
anyway, give your slip.
You kindly allow direct the matter to appear in the list.
I don't know about that.
Matter may be included in the list.
We'll
of
see.
charges,
Right,
Lordship.
move an urgent motor. My lord, direction was to file and it will be hard. My lord,
You have mentioned yesterday also.
yes.
Yes.
That's why I am filing today. There is the urgency. It will be a hard on my
Sir, it is what? Appellate side matter?
appellate side.
Not today. Don't mention it.
Otherwise, my lord, I am not allowed to.
That's all right.
examine it.
Mention it tomorrow.
My lord, appellate side mentioning, my lord.
Tomorrow. Not today.
Appellate side mentioning for non-prosecution.
Appellate side, mention it tomorrow. We'll have it for now.
Appellate side for upgradation.
Tomorrow, sir. Tomorrow. Why?
Notice was served, my lord.
Tomorrow. You do it tomorrow.
Your lordship, I'm praying for inclusion in the daily list.
Original side.
It's a minor correction, my lord, that respond number 5, your lordship, it has been mentioned in the order. It should be, my lord, 4 because there is no respond number 5 in the.
Just make this correction. Respond number. Necessary correction be carried out. Make that correction.
My lord, I may be permitted to mention one item, my lord.
Yeah, wait a minute. Yes, madam, what are you saying?
My lord, there is an extreme urgency, my lord. I have filed one CAN application. The
Original
municipal
side,
authority-
appellate side.
Appellate side, my lord. They are
Not
going to
today.
demolish my
Not
building.
today, madam. Tomorrow. Sorry.
My lord, let it be specially fixed, my lord, because there is an
Tomorrow,
extreme.
madam. No. Tomorrow, mention it tomorrow. We'll see it. Yes.
My lord.
This pertains to the arcade of Oberoi Grand Hotel, East India Hotels. Look, this is the only arcade of a institution hotel which is filled with hawkers. This is an application essentially for getting our arcade to be freed from hawkers. Well, we have come on three legal principles. One is discrimination. Two other hotels in the city, not of the rank of Oberoi Grand, slightly lesser, which have arcades. One is the Lalit Eastern, Great Eastern, no hawkers, and the other is Park Hotel on Park Street, arcade, no hawkers. So allowing this is a discrimination. Second point is they are allowing people to be there. Those who were not existing vendors under the KMC Act. That is a condition, if at all, a particular area has to be not a no vending zone, only existing. None of these people have licenses under the KMC Act. And number three is that they should consider the necessity for, without just by non-application of mine, not declaring this arcade as a no vending zone is contrary to the purpose and principle of this town vending act, town vending act. But this is the three grounds on which, and interim orders which are subsisting today, passed by the division bench presided Honorable Mr. that for allowing the repairs to be done. Order copy now. So that order was.
That's a different thing. As far as the squatting is concerned, that's a different thing altogether.
Yes, so that's the interim order for at least repairing to be carried out. And well, our arcade has a lot of shops who are our tenants, and we can't get any enhancement of rent, and we can't use that arcade also for the, like the Taj Mahal in Bombay, hotel with an arcade, which they have one or two old shops and it's entirely decorated. There you have your private entrance, and our entrance used to be through that. We can't use it. And what is pressing against us is now, of late, after this impugned order passed in 2020, 23, which we have challenged it, 24 March, they've even allowed, there used to be a gap of 20 feet from our gate. I've got photographs. We used to have, beyond the 20 feet, there were hawkers allowed. And now they've reduced it to 5 feet. As a result of which, we have lost our IPL accommodation for the teams. And it is causing traffic jam. I mean, now it's under renovation, we are doing it, but it causes traffic jam. It causes, apart from the embarrassing show and the first Oberoi, the second Oberoi hotel in India after the Oberoi Clarks in Shimla, and Calcutta's second oldest hotel after Great Eastern. So, and the first 5-star hotel of Calcutta, Oberoi Grand. Lordship, what we have challenged here is a decision of the.
But today, I think it is the application or the application GA3 is pending, right?
Those are all, I think, addition of parties. They've all been allowed to.
No.
Anyone
had
pending?
filed 2 applications for addition of parties. They are allowed. My lord, we have been impleaded as parties. My lord, we maybe submit the affidavit in reply, my lord, pursuant to the direction of the Honorable Division Bench. When, my lord, the petitioner went up in appeal, the Honorable Division Bench directed us to, my lord, submit affidavit in opposition.
Time has expired, possibly
Yes,
6 months back.
No, my lord, it was, my lord, we had a 3 days delay. That is the reason we could not submit it before the department. If your lordship may kindly condone the delay, we have served, and they have also, my lord, served a copy of the reply to this.
Your delay application is there?
My lord, delay in, my lord, my lord, preparing of the affidavit in opposition.
How much is the
My lord,
delay?
3 days, 3 days, 3 to
There
4.
are
Very well, Lordship. We want to get it hard. We don't want to come in.
No, they have, my lord, accepted this opposition. They have submitted served a reply to this.
So let it be. I mean, we have served them subject to the court accepting.
So we
But
don't-
no affidavit has come from the corporation, even though directions were given. So I take it that they will not give.
They will file, Mr. Ghosh.
I'm just telling to my learned junior friend, my lord, that I should have taken a prompt action regarding, because that issue, whatever, actually, my lord, they are questioning about our decision. I
So you
can
have to-
just, my lord,
You have to file your reply.
yes, my lord, yes, my lord. You say kindly give me something.
Without their reply, Mr. Mitra, how can you?
They have never really opposed us. Sometimes there are two reports which were given on condition of the arcade.
They have not opposed, but it is their action only which is causing all the.
There's a town vending committee.
Yes.
It is not really their action. It's a separate act and separate town vending
That's
committee.
right, under the Street Vendors Act.
Yes, Street Vendors Act. So that is the so. But then if they do not file, then we can. This is given. Direction was given
They
last.
must be. I don't think so. There will be a separate lawyer for the town vending committee. You must be handling.
I used to appear.
You appear for the town vending committee, yes. So do you need to file a separate affidavit for the town vending committee, or you are going to adopt the same stand, whatever the corporation is going to?
Yes, my lord, of course, my lord, because the some my lord, the connection is there, whatever the functions, my lord, the municipal commissioner, because of this, my lord, the chairman of this, my lord, the committee itself.
So, I mean, they're really one. Though there was a separate respondent.
Some members who are from the, the vendors and all that are also members of the town.
So, Lordship, if Lordship feels that their affidavit is necessary, Lordship, kindly give them one last chance. Otherwise, it's been going on for last 1.5 years now.
All right, you show me what are you filing. First, let me. There's one application. GA3 is yours.
GA3 is not our application. GA3
Who has filed GA3?
GA3 well, GA1 and 2 we had
1 and
filed
2 is allowed.
allowed. We have been impleted.
GA3 is pending.
GA3 is, my lord, probably somebody else's application.
Who's appearing in GA3?
And my lord, there was a direction of the Honorable Division Bench to, my lord, file an application under Order 1, Rule 8, so that all the interested parties can
Correct.
approach before this Honorable Court. Appraise your lordship.
So that is how GA3 has also been filed. Though that has been pending for a long time, but who's appearing in that? And you were supposed to do a paper publication, Mr.
Yes.
Mitra?
Yes, we have done that. We have done everything. Paper publications done. Whoever has wanted
Nothing
to.
is on record.
Not-
Nothing is on record.
Have you brought it on record? Paper publication.
No. You have to put that on
Bring
record. There's a
bring it
direction.
on record.
There's a direction. You have to comply by the order of the
No,
division.
we have
bench.
complied. No, but then you're going to file an affidavit of service keeping on record this paper publication has been done.
You have to put that on record.
Yes, put that on. Put that affidavit of service. That we shall do it by the next day. These are the what? The GA likha nahi to GA.
These are replies
To what?
to in the main writ to the affidavit.
There was
of opposition
previously a
and
writ
any
petition
interventions.
filed, my lord, by the petitioner. In that writ petition, my lord, her ladyship, Justice Amrita Sinha, directed the town vending committee to take a decision. But the town vending committee removed the hawkers from the facade of the building.
No.
My lord,
I wish that was so.
my lord, directed the town vending committee to take a decision. The town vending committee decided that all the hawkers were sitting in the facade. Previously, there were hawkers on both sides of the pavements. Now, my lord, pursuant to the decision of the town vending committee, hawkers from the facade were removed and they were restricted to only one side of the pavement, and that too within 1/3 of the pavement.
But that's the rule. That's the
That
that's
is
the
the
regulation.
Which is is challenged before you.
Is that being followed?
My lord, that is being followed. That is
followed.
That is being strictly followed, my lord, and we
Well,
have given an
I am
argument
agreed
that
by
we will
the decision
not
of the
violate.
town vending committee on two scores. One is this should be a no vending zone. To allow vending here, I'm challenging that. Number two, if at all vending has to be done, 1/3 is nothing, is no favor because that's the regulation. 1/3 only they can be hawking. Well, there has to be a 20 feet gap from our gate. But that is something, Lordship, which is very important for our movement of our vehicles. 20 feet gap from our gate, and if I can't get the no vending
If
zone.
one of the entire facade of the building, my lord, is on the footpath. The entire area to be kept vacant. That is
Yes.
one of the
Like you've done with Park Hotel, like you've done with Great Eastern Hotel, you say you're not allowed vending there. Why can't you do this for Oberoi Grand?
Great Eastern is a different story altogether. They have built their own, my lord, garden on the pavement. So there is no.
I would love to make it.
They will also do it.
Give-
If you allow them to do it,
Would do
tomorrow
it
they'll do it.
much
area is
better.
different.
I will do it
Area
much
is different.
better.
Pending cases.
They'll
my
make it
lord,
like Dubai.
pending
Yes.
Give them the
cases.
opportunity, they'll do it. If you
Area is
With regard
different.
to that illegal structure, my lord, as far my information goes, there are pending cases, my lord, asking for demolition of that particular
What?
garden structure of Lalit Great Eastern.
Lalit is as it is, not a single vendor there. Park Hotel also.
see, anybody who's encroaching on the public land. See, these are all encroachment on the public land. The corporation can always take a action on
My
that.
lord, this is with regard to Oberoi, my lord. My learned senior would agree that since our childhood and
No,
since
not
his
from my
childhood,
childhood.
this is
Oberoi's
the traditional market.
Oberoi's entrance was from Chorangi. Lordship would not have seen. My childhood, my memories, my father, is Oberoi's entrance was from the from a small door on Chorangi, like Oberoi, like Taj Mahal, Kolaba. There was an entrance here, and they wanted to go and stay. There was this lobby, small lobby, but then the entrance was changed to a much grander entrance on the side, which is now in existence. But previously, it was just Taj Mahal, Bombay, a small door for the entrance to Oberoi Grand. Till 70s, till mid 70s at least, I remember. There was a single hawker there.
Previously, both the sides of the pavements were occupied by the hawkers. Now it has been regulated by the town.
It's to your regulation that 1/3 only of a
I was not born, so I can't tell you. So, affidavit in opposition filed by the respondent number 11 to 66.
My replies are there. Should I file them next day, or should I keep them with me? Whatever affidavits we have received in the writ petition, we have given our reply.
For condemnation of delay also?
No, my lord, there is
No, Lordship, I am not opposing. Let them.
You are not opposing it. It's taken on record. Though learned counsel for the petitioner states that there is a delay of 3 days in filing the affidavit in opposition, the same is not opposed by the learned counsel for the petitioner. Full stop. A reply to the said affidavit in opposition filed by the petitioner is also taken on record. The second little affidavit in opposition filed by respondent number 67 to 88 is taken on record. Same order. Same.
May I make one prayer that
Same.
since the
There's a
hotel
delay
will
of
be
3 days. Learned counsel for the applicant states that there's a respondent states that there's a delay of 3 days. The same is not opposed by the counsel for the petitioner. Reply to the said affidavit in opposition filed by the petitioner is also taken on record. Learned counsel for the respondent Calcutta Municipal Corporation, who also appears for the town vending committee, respondent number
9.
town
Respondent number
vending
9.
committee, respondent number 9. Town vending committee, respondent number 9 seeks and is granted further time of how much time, Mr. Ghosh?
Your Lordship, 1 week after the vacation.
Well, may I make one prayer for our
fixed time to file affidavit in opposition, just affidavit in opposition, reply to the same if any within 2 weeks thereafter. Yes, Mr. Metso.
But the entrance there should be some space kept on the two sides, because our trucks,
Whatever the arrangement is, we are not touching that arrangement, right?
can it be extended a bit for us, because our movement
So
of
then
vehicles.
for that, I need to hear.
Lordship, may I then request same position whichever day Lordship keeps it?
This will come only in after vacation.
Yes, Lordship, but kindly make it peremptory for them and fix it.
After 10 weeks. Give a date, Manoj.
On 28th or 27th November. On 27th November.
27th suits you?
Yes, Madam.
27th.
To 27th.
27th November. Then I'm not taking up GA3 because there's nobody for the applicant. I'll keep the GA3 pending.
Then the Lordship kindly add, if there is a GA3 addition, let them be added. And
Let them be added? All
let them file their affidavits.
All right. GA3, there's an application filed by the
Let them file the affidavits by that date.
applicant
keeping all
seeking
the questions.
impleadment as party respondent to the present writ petition. The applicants claim to be carrying on hawking activities in the vicinity of Oberoi Grand,
Which is disputed.
vicinity of Oberoi Grand Hotel, full stop. The petitioner in the present writ petition has challenged the order dated 13/3/2024 passed by the town vending committee, whereby the petitioner's request for declaring the entire grand arcade as a non-vending zone was rejected, full stop. Since the applicants are hawker, hawkers carrying on activities, carrying on business in the said area, comma, they are likely to be affected in the event the writ petition is allowed. Full stop. Accordingly, the applicant claimed themselves to be the necessary parties to the present proceedings. Full stop. Learned counsel for the applicant, though none appears for the applicant. The application states that similarly situated persons, their application GA1 of 2024 and GA2 of 2024 has been allowed. In terms of the, in view of the prayers made in the application and on behalf of the concession given by the petitioner that he has no objection to the present application being allowed, the application GA3 is allowed.
Let them file the affidavit with them.
The respondent so-and-so is added as a party respondent to the present writ petition. He is permitted to file his affidavit in opposition within a period of 4 weeks, reply to the same, if any, within 2 weeks, list on same date, 27.
27. But all allegations, because we are denying that they are really hawkers.
वहाँ जहाँ वो लिखा है ना rejected, learned counsel for the petitioner states that the persons who have moved these applications
Are not
hawkers and that they are illegally carrying out the business activities without obtaining any valid license from the municipal authorities.
Lordship, one line that if it could maintain the position, same position.
Affidavits and all.
It will. I don't know.
That's our fingers crossed.
After vacation, what
Because
will be?
we want a resolution. We wanted the matter disposed of. I know that. But then our Calcutta High Court does.
If I would have heard it earlier, I would have disposed it off this way, that way, whatever.
I know that's what we are. We want a disposal of
You know,
this.
but unfortunately, the pleadings are not complete. Otherwise, if I pick a matter, then I try to. But we'll see. Thank you.
Grateful.
I am for the state respondent, madam.
Yes.
Well, I appear for the writ petitioner, but I'm challenging the.
I'm for the
Hey,
respondent
Ria.
seven.
Ria. GA3.
State.
I am for the respondent number 7.
Well, I'm challenging the order of the building for allowing retention of the entire 4-story building, principally on the ground of violation of the principle of natural justice and not following the order of the court permitting me to participate in the proceeding. Second major point is that the reconstruction plan which was granted by the Kolkata Municipal Corporation, having regard to the nature of the construction, the plan could not have been sanctioned like that. Because under different sections, the plan should have been sanctioned, but that process was not undertaken. Third point, my lord, if I take it that the reconstruction plan stands after the entire building was pulled down, entire building was demolished, then whatever the construction has been made, that can be said to have been made in terms of the reconstruction plan, because plan is not there then. Then he has to make the construction, my lord, in terms of the making an application, fresh sanction plan ought to have been obtained. Now, my lord, and another aspect is there, the bifurcation of the particular premises, my lord, into two premises, my lord, 68 College Street and 68/1. First of all, my lord, I showed to your lordship the order in the earlier proceeding, what is the direction of the honorable single bench. It has really come to straightway at page, my lord, 129. I
129.
129, last part of the first volume, last page, last part document. Alleges unauthorized construction at premises number 68/1 College Street at the behest of the respondent number 6 The learned advocate representing the respondent says questions the local standard of the petitioner to maintain the present lead petition. It is contended that the petition has no interest in the share of the or share in the respondent number 6. In the light of the report filed by the corporation, this court finds it is necessary to examine the issue local standard that apart. The report as filed by the corporation is produced below. Illogically, since the report, I draw your lordship, my lord, after 3-4 lines during inspection. The report has been quoted.
During inspection, it was also
During inspection, it was also revealed that the person responsible has already demolished the existing structure which has violated the condition of the said sanction plan. Therefore, my lord, the reconstruction, according to them, the reconstruction plan has been taken. Therefore, the existing structure is here on that part of certain constructions to be made. But here in this case, in the process of making construction, entire the existing building had been demolished, and the condition of the sanction has been violated. Then the court directly in my view, since the corporation has already initiated demolition proceeding under section 401, no further order is required. But this one the writ petition was disposed of. Then, my lord, I prefer an appeal.
Yes.
Against this order.
Yes.
The appeal court, my lord, passed an order, my lord, on 20th March. Illogically come to that, my lord, the order, which is at page, my lord.
But both these are appealable orders.
My lord.
These are
The
appealable.
violations of principle natural justice and, my lord, the findings of the honorable or the special building, he has not, my lord, taken into consideration in law also, my lord. I mean, basically, my lord, he has not, my lord, given any opportunity of hearing, despite the giving direction by the division bench. The division bench has kept it open, formally adjudicate.
Show me that.
Illogically, say, first of all, illogically, see, my lord, page, my lord.
Just 1
160.
second. Just 1 second. Just 160. Yes. It is directed against him.
Appeal is directed against an order dated 5th February 2025, passed in Sajjan by which the writ petition was disposed of by the learned single judge after finding that the Kolkata Municipal Corporation KMC already initiated demolition proceeding under section 400 subsection 1 of the Kolkata Municipal Corporation Act. Then your lordship, keep over to the 3rd paragraph. The report claims that the existing structure was demolished, which violated the condition of the reconstruction sanction plan dated January 31st, 2024, and therefore the KMC issued a stop-work notice 401 of the Act on September 23, 2024. As the construction was continuing despite the stop-work notice, a first information report was lodged against the person responsible under section 401 capital A of the Act 1980 on September 25, 2024. KMC authorities are proceeding under section 400 of the Act. The special officer building is hearing the proceeding under section 400 of the Act in respect of the premises concerned. Then your lordship kindly come to the next page 162. Last but one paragraph, special officer building. My lord, got it, my lord?
Yes.
Special officer building will proceed to dispose of the proceeding under section 400 subsection 1 of the Act in accordance with law after affording reasonable opportunity of hearing to the private parties. Before us, special officer building is at liberty to hear such other parties and consult such documents as it deemed appropriate. It is expected that the proceeding under section 401 of the Act is concluded as expeditiously as possible and preferably within 6 weeks from date. No doubt the special will pass a written order which will be communicated to the parties forthwith. Therefore, I was allowed to participate in the proceeding. Now, lordship kindly come to, after this order,
yes,
I wrote several letters. If you lordship can see that page, although it was not necessary, but I wrote letters. First on 27th of March 2025, that is at page 131. Requesting them to intimate the date of hearing of the proceeding. Then you logically come to my lord next time the document, my lord, represent at page 142. 142, my lord, I asked for the certain documents to be provided to participate in the hearing. Logically, see, my lord, what the documents are required to take a proper defense in the proceeding. 6 documents are required. No response. No communication. Then, my lord, the last representation I made at page value 153. They did not respond, my lord. No manner of communication, no date of hearing was intimated to us, no document was supplied. Then I found, my lord, the construction again, my lord, started. Because the court initially, my lord, injuncted them not to proceed with the construction work. When I found the construction is going on, then I filed a contempt application before the court, division bench. The division bench, my lord, passed the order on 11 July 2025 at page value 164. Since in the meantime the order had already been passed, the court, my lord, kept every point open, including the violation of the natural justice, which was not provided to my client for agitation in the appropriate forum. The court said that technically the special officer did not adhere to the order of the court dated 20th March 2025. The court was not minded to invoke the contempt jurisdiction, but the court said that clarified that the issues raised by the appellant, that the appellant was not heard prior to the order dated 24th April 2025 being passed by the special officer building, and also with regard to the legality, validity, sufficiency of such order are kept open to be adjudicated and canvassed before the appropriate forum. Now you logically come to the admitted position is that, but I was not given a hearing, no document was supplied. It was in fact, my lord, behind our back, my lord, the order was passed. Now the order which was passed by the special officer building, you logically come to that, my lord, the order at page 168. It is apparently clear, my lord, you see the details of the unauthorized construction. The construction has been made after the demolition of the existing structure completely. And that is also in the report. And you logically see, my lord, that it said that there is no complaint, that is not the right thing. Wrong statement recorded in the order. And then you logically see, my lord, the violation, the rules, front, rear, side, structural, everything has been infringed. The matter only heard by the person responsible and the special officer building. Then the special officer building, the contrary, my lord, the facts have been noted. You logically see, it is reported by the department. After inspection of the site, the walls are demolished and new brick walls have been constructed. It is noted that the MPNL structural engineer, ESC, submitted a report dated 3rd April 2025. It is also noted that the old walls of the existing building were collapsed during the construction of slab, and new RCC columns are insured in between. But it is the facts stated in first paragraph, contrary is in the second paragraph. It is also reported that the existing structure was demolished, which violates the conditions of the sanctioned building plan. Then, since because the report structural stability report has been submitted, the special officer building simply said that on that basis I am inclined to allow the retention of the 4-story building. Your Lordship, I will kindly come to
You are the complainant.
yes, madam. Now you logically come to basically the violation of the principle of natural justice.
Principle of natural justice division bench has also seen it.
Also seen it and also kept it open for agitated.
Kept it open to be raised at the appropriate forum.
Yes, madam.
And
Now,
the appropriate forum will be the building.
No, you logically see, madam, that issue, in my respect submission, that cannot be considered in the light of that provision. And secondly, my lord, in this particular case, my lord, I have challenged the grant of because of the entire construction which was allowed by the special the building. After that, he could not have said the detention of the entire structure. You also comes to my lord, section 390. Because what about the plan sanction, reconstruction, that stands negated, particularly after demolition of the existing structure.
Yes.
I can see, my lord. It says that to erect a building means erect a building is to erect a new building on any site, whether previously built upon or not. Therefore, my lord, here in this case, my lord, it was built upon once, it was not now. Therefore, he is erecting a building, then what modalities he has to adopt for obtaining the sanction of the building plan. And then it says that to re-erect. Re-erected also, my lord, comes within the purview of the definition to erect a building. These are the constructions which comes within the meaning of the to erect a new building. And in the event of, my lord, any building, my lord, comes within this purview, then you logically come to, my lord, section 394. Well, he has to make an application under section 394. Well, here the plan has not been sanctioned like that. I am questioning about the sanction of the reconstruction plan in this petition. And even if I take it, the reconstruction plan was validly issued, if you take it, then after the building has been totally demolished, therefore there is no scope to execute that reconstruction purported reconstruction plan. Therefore, it was incumbent upon the person, my lord, to apply afresh for sanction of the building plan. That has not been done. Therefore, my lord, that plan, the building which has been, my lord, standing there, an absolutely new building, that can be said to be reconstruction or because reconstruction, first of all, reconstruction term is not found in the act itself. It says the re-erection and what was the re-erection that has been provided here. Therefore, it's a completely new building without having any sanctioned building plan. Therefore, it stands, my lord, in my submission, the total unauthorized construction. And I have, my lord, deferred to, my lord, some of the provisions here that for that purpose, the plan, therefore, my lord, twofold, my lord, the issues I have raised here. First of all, the plan issue cannot be decided at all by the learned tribunal. Plan issue cannot be decided by the learned tribunal. Whether the plan stands or not, whether, my lord, he ought to have sanctioned in a proper sanction under the provisions of law, having regard to this and also the building rules, but that cannot be decided. And my lord, considering is that the principle of natural justice that can also be decided, considered by the special of the building. But special with the building, despite receiving the notice and also the authorities having failed to respond anything, but what should I achieve in going the building tribunal, because this building tribunal say the building standing over the years, it will continue. That cannot be the idea of the law. But therefore, my lord, it is interlinked with the sanction of the building plan construction. If the building plan does not stand at all, ecologically on the face of it, the deconstruction plan is not there when the construction has been raised.
Yes.
Well, I'm for the respondent number 7. I will take the 2 points, my lord. Lordship will kindly look at once more page number 160.
For the corporation, you are appearing? Yes, Mr. Mukherjee.
Should I, my lord?
Yes.
I start from
May I?
Let me hear the corporation.
Certainly.
Well, another issue is here, I have also raised, well, regarding the area of the plot, same area, 2 premises has come into effect, that the assessment department has to respond to that. That point has also been taken here. How it all of a sudden come to a 68/1 to grant. The original building, but the site was, well, it's a factory premises that was changed to a, well, residential, but the dwelling house, but residential conversion category.
That is not the subject matter here.
Well, that has been raised here.
This is not, you are only challenging this order of.
No, this order, there is also one because of the it connected, because the site is the issue for consideration.
So, should I
Yes.
start, my lord?
Yes.
Your lordship. So I start from the last point. Within the scope of misjoinder of cause of action.
Yes.
One is related to the building and construction. The second, now what my learned senior friend says, Mr. Ghosh, is relating to the assessment, how the separation was done. So it is actually misjoinder of cause of action. Now, my lord, as I have submitted, your lordship would kindly take page 164, that is the order passed by the Honorable Division Bench in the contempt petition preferred by my learned senior friend's client.
Yes.
My lord, 164. The learned advocate appearing for the petitioner submits that although the direction was on the special officer to dispose of the proceedings under section 401, this is relating to, my lord knows that it is relating to demolition of the Kolkata Municipal Corporation Act in accordance with law. After affording a reasonable opportunity of hearing to the private parties, the special officer did not take any step. He submits that the appellant was not harmed by the special officer building. The appellant is not aware of the stage of the proceedings, if at all. The special officer building initiated one. Learned advocate appearing for the alleged contemner, that is corporation, submits that the special officer passed an order on April 24, 25. In his usual fairness, he, however, submits that the special officer building did not hear the appeal. Learned advocate appearing for the appellant submits that the action of the special officer in not hearing the appellant sounds in contempt of the order dated March 2025, which required the special officer building to hear all private parties. Relevant operative parties given. My lord, I do not want to trouble your lordship. The report filed in the court demonstrates that the special officer passed an order on 24th of April 25. However, the special officer did not hear the appellant before us prior to passing his order. Technically, the special officer did not adhere to our order dated March 2025 strictly by not hearing the appellant before us. However, the special officer passed an order dated April 24, 25 purporting to act in terms of our order dated March 2025. Since the special officer passed an order dated April 24, 25 in the proceedings under 401 of the Act, we are not minded to invoke the jurisdiction under Article 215 of the Constitution of India or under the provisions of the Contempt of Courts Act. We have clarified that the issues raised by the appellant, that the appellant was not heard prior to the order dated 25 being passed by the special officer building, was also with regard to the legality, validity, sufficiency of such order are kept open to be adjudicated and canvassed before the appropriate forum. And in the understanding of the petitioner, he thinks that the appropriate forum would be a writ court, and thereby bypassing the tribunal. I bow down to your lordship, as it had fallen at the very outset that this is an appealable order. Now, my lord has seen that the order was passed on 24th of April 25, and this contempt is coming on 11th of July 25. Now, my lord, there is a 30 days time within which the appeal has to be filed before the tribunal under 400 subsection 3. Subsection 3 of 400. So this is all related to, my lord, the illegal, because he proceeded first saying that it is an illegal construction without plan and whatever is there. Now, my lord, now the point what he is raising is, my lord, is a very subtle deviation from the initial argument. He now says, well, a plan was given for reconstruction. Now, in the garb of that reconstruction plan, what the person has done, he has pulled down the entire structure and he has constructed afresh. So this very purpose of reconstruction plan is negative. It should be cancelled. It should be cancelled, rescinded. If that is to be done, my lord, the proceeding is under, my lord, would kindly take section 397. My lord, in my humble way, my lord, I have read the writ petition. I have gone through his representation, but nowhere I could find that he has invoked 397. 397, my lord, would kindly see, is a specific provision relating to cancellation of the plan. 397. My lord, 397, your lordship has
Sanction or provision sanction according
if at any time after the communication of sanctions or provisional sanction to the erection of any building or execution of any work, the municipal commissioner is satisfied that the sanction or the provisional sanction was accorded in consequence of any material representation, material misrepresentation or any fraudulent statement in the notice given or information furnished under section 393, 393A or section 394 or section 395, he may by order in writing cancel for reasons to be recorded such sanction or provisional sanction, and any building or any work commenced, erected or executed shall be deemed to have been commenced, erected or executed without such sanction and shall be dealt with under the provisions of this chapter, provided that before making any such order, the municipal commissioner shall give a reasonable opportunity of to the person as to be affected as to why orders should not be made. So these two are two, lordship has seen, these are two separate compartments. One is relating to the illegality in the structure and other relates to the cancellation of the very plan. That goes to the root of the matter. And in my most respectful submission, when the division bench in contempt took notice of the fact that the hearing was not given, and yet at the same time the honorable division bench came to a finding that we do not find that there is any contempt by which we can invoke 215 of the Constitution, Article 215 of the Constitution of India, or any provision of the contempt. That sets the, now leaving it to the appropriate forum, my respectful submission is, if he is agreed my lord, would kindly take section 3. He has to go before the building tribunal. Now, my lord, kindly take subsection 3 of 400. Subsection 3 of 400 and the point of natural justice can also be considered by the building tribunal. My lord, would kindly take section 3 of 400. Any person aggrieved by an order of the municipal commissioner made under subsection 1 may within 30 days from the date of the order prefer an appeal against the order to the municipal building tribunal appointed under section 415. His case, as at the outset, what he had submitted is point of natural justice, that he was not given any hearing. That point is set to rest. Today, he has not made any application before any authority or even before the division bench, saying that that finding ought not to have been there in the order. Or rather, the division bench ought to have interfered, coming to know that no hearing was given. That is not the case. The case is now what he wants to make is that natural justice goes. Now he says the plan issue. If I have heard Mr. Ghosh very correctly, he has said plan issue cannot be decided by building tribunal. Yes. I ask a question to myself, where is the plan issue? Where is an application under 397 to say that the plan should be cancelled or rescinded? And it has to be done before the municipal commissioner. It has to be done by the municipal commissioner. And that has to be adjudicated. That is also not at least from the pleading side, do not find. It is a submission from the bar. There is no record to show that. It's a submission from the bar. So, my lord, I most respectfully and with the deepest of respect and all humility I submit, my lord, he can go before the tribunal. He should be, my lord, directed to go before the tribunal. Those are my respect.
Yes, sir.
Two lines. Lord, kindly look at page number 1. I adopt fully this argument, Lord. And Lord, kindly look at page 169.
169.
69. It starts from page 168.
Yes, sir.
169, second paragraph, Lord.
Yes, sir.
Has Lordship got it, Lord? In consideration that the existing building is in dilapidated condition, has been re-erected, and structural stability is confirmed by ESC supported by test reports, I am inclined to pass order to retain the structure on payment of fees under section 400. So, my lord, this is a question. This part has to be, my lord, negated by the, my lord, either the tribunal or appropriate authority. My lord, thereafter, my lord, will kindly look at, my lord, the last part. The order be given effect to by the mayor in council. The order has been passed on 30th May 2025. My lord, will kindly come to the earlier page also.
Yes.
Page, Lord, 167.
Yes.
My lord, will kindly look at the last lines. As per the aforesaid order, this department issued regularized sanction plan dated 13th June 2025. All the three authorities have signed it. These are also not challenged before your lordship in my full submission. I tried to check up. Now, Lord, in respect of all these, Lord, this is the only municipal building tribunal who can decide the entire matter. And number one, my lord, and third party interest has already been created in respect of the premise. And I have paid all the fees, whatever is payable. So, my lord, in my submission, my lord, this petition possibly, my lord, your lordship will pass the order to, even if there is a, my lord will kindly, whatever lordship will decide.
So that is the object, all is over. According to my understanding, third party.
Not factual,
I'm sorry. I understand.
Investigation is.
I understand.
Yes.
Just I am
Lord, I am saying, Lord.
I have the police authority. I made a inquiry before the site. This is my report in the last paragraph.
Police authority.
Police authority.
Report is that the building has been constructed.
No, whatever the factual aspect is there, my lord, that has to be decided. And that can be decided only by the municipal building.
There is no factual dispute here, but I submit to your lordship. First of all, my lord, I don't agree with the interpretation given by Mr. Mukherjee with regard to 397. 397 is application for a different purpose, where the plan is obtained, my lord, material misrepresentation, fraudulent statement in the notice. I have not made out that case here. Therefore, section 390. My point is that as soon as I, my lord, as soon as I pull down my building entirely and raise the construction, the plan which I have, the plan, whatever the nature it is, it stands inoperative. It cannot be acted upon because automatically different situation comes up. Because now it is an entire land. Then you are to come within the purview of 394, referring to section 390. This is the position of law. And second, my lord, the Honorable Division Bench, of course, my lord, noted that I have not given a hearing. That hearing, my lord, although he has been not been punished, my lord, he is, my lord, happy that the court has not punished him because the order had already been passed. That is the reason the court did not mind it for taking action against the person responsible. Although clearing violation of the court's order is there, despite my repeated representations. Now, my lord, my answer is saying that go to the tribunal. Therefore, my lord, third party, fourth party will come up. Then ultimately, entire issue will not it stands as a zero. That is the whole purpose of both of my learned friends. Therefore, I am submitting to a lordship. The lordship, my lord, adjudicate this issue, and my lord, that issue cannot, all the issues cannot be decided, even if I go to the tribunal, cannot be decided. And tribunal will only go by the order which has been passed by the special officer building. And special officer building on the face of it is bad that he has not come to any finding on that. He has merely said that I am inclined to pass an order because the structural stability certificate has been granted by the implant structure engineer. If this is the finding or the consideration of the statutory authority, well, I'm respectfully submitting, well, that can be encouraged at all.
Take note. Petitioner has preferred the present writ petition challenging the order dated 24th April 2025 passed by the Special Officer Building in demolition case number 37. In demolition case number 37-D/V/24-25, comma, as also the sanction construction plan bearing sanction plan dated 31/1/2024 in respect of premises number 68/1 College Street, Calcutta. Learned counsel for the petitioner, Mr. Ghosh, submits that the petitioner is having shareholding rights over the aforementioned premises, whereas the respondent number 7 is the owner and respondent number 8 is the tenant of the premises mentioned above, herein above, full stop. Respondent number 8, being the family company of respondent number 7, is carrying on its printing business from the said property, full stop. Said property. Carrying on printing business from the said property. The petitioner noticed certain unauthorized construction being raised at premises number 68/1 College Street, Calcutta, and accordingly lodged complaints before the respondent corporation, full stop. Since no action was taken, comma, the petitioner approached this court by filing WPO 909 of 2024, full stop. This court, wide order dated 5/2/2025, comma, disposed of the said writ petition based on a report filed by the corporation, which indicated that demolition proceedings under section 401 of KMC Act had already been initiated, full stop. Aggrieved thereby, comma, the petitioner preferred an intra-court appeal being APOT 17 of 2025, full stop. The Honorable Division Bench, wide order dated 23/2025, directed the Special Officer Building to conclude the demolition proceedings within 6 weeks by passing a speaking order after granting an opportunity of hearing to the petitioner. As well as the private respondents therein, while leaving it open to the authority. Hearing to the private respondent herein, while leaving it open to the authority to hear other interested parties and to examine the documents deemed fit, full stop. Since the said direction was not complied with, petitioner preferred CC number 91 of 2025, full stop. In the course of those proceedings, it transpired that the special officer building had already passed the final order dated 24th March 2025 in the demolition case, but without affording an opportunity of hearing to the petitioner. While order dated 11/7/2025, this court dropped the contempt petition, clarifying that the legality, validity, and sufficiency of the order dated 24/4/2025 could be examined are kept open to be adjudicated and canvassed before the appropriate forum. Full stop. The petitioner has now filed the presented petition challenging the order dated 24th. Order is 24th, right?
Well, the order is 24th April 2025.
24/4/2025. 4/2025. And the validity of the sanction reconstruction timetable 31/1/2024. Full stop. Learned counsel for the petitioner states that this court poses the question to the petitioner that since the present order is an appealable order, he shall file a petition before the municipal tribunal. Full stop. Learned counsel for the petitioner, Mr. Ghosh, submits that though the order is an appealable order, but the same shall be entertained by this court since principle of natural justice has been violated and that the relief claimed by the petitioner cannot be adjudicated upon by the learned tribunal. Full stop. To impress upon his argument, Mr. Ghosh states that the order dated 24/4/2024 has been passed in violation of the direction 24/4/2025 has been passed in violation of the directions passed by this court in WP number ऊपर जो WPO number है AOPT number 17 of 2025. AOPT 17 of 2025. Full stop. There was a specific direction given by the division bench that the petitioner shall be given a hearing before the special officer building before passing of the speaking order. Full stop. He states that no such hearing was granted to him. Though this point is no longer res integra, since the petitioner has challenged the same point in the contempt petition 91 of 2025, wherein the court had already observed that though no hearing was given to the petitioner, but yet the order passed by the special officer building dated 24/4/2025 was the order passed by the had closed down the contempt, stating that the order passed by the special officer, no contempt is being made out. It was further observed in the contempt petition that as far as the legality, validity, and sufficiency of the order passed by the special officer building is concerned, the same can be adjudicated and canvassed before the appropriate forum. Full stop. Learned counsel for the respondent municipality, Mr. Mukherjee, states that the appropriate forum for redressal of the issues raised by the petitioner would be the municipal tribunal, since the order is an appealable order, and states that the petitioner is entitled to move the municipal tribunal. Full stop. In view of the submissions made by the counsel for the parties and the documents produced by this court, this court is of the view that the present writ petition is not maintainable, since the order dated 24/4/2025 is an appealable order, and that the grievance raised by the petitioner that he had not been granted an opportunity of hearing and principles of natural justice have been violated is no longer res integra, since this court had already adjudicated upon the said contention in contempt petition number 91 of 2025 and had observed that the legality, validity, and other aspects of the impugned order are left open to be adjudicated before the appropriate forum, which, according to this court, would be the building tribunal, wherein the appeal from the said order shall lie. Full stop. This court finds that there is an efficacious alternate remedy by way of an appeal before the municipal building tribunal. This court is not inclined to entertain the present writ petition. Full stop. Accordingly, the present writ petition stands dismissed with liberty to the petitioner to avail statutory remedies in accordance with law.
I'm extremely grateful.
Yes, sir.
Yes, Your Lordship, on an earlier occasion, I had taken time from the Honorable Court to peruse through the report, which is submitted on the last occasion.
Yes.
Your Lordship, before filing an exception or opposition to the same, I would like to point out 2-3 things which
Don't point out anything. Either you file it or you don't file it. And let's argue the matter.
I'll
and
file
finish
it,
off.
my lord. Just
No,
one.
I don't want to hear you. Why should I waste the time of the court?
Okay, I'll file
Why
that.
do you want to waste the time of this court?
No, my lord, I'll file that.
Why you have not filed it?
My lord, I'll file on the next occasion.
No, but what is stopping you from filing it? You have taken time.
My lord, there are a lot of irregularities and anomalies.
No,
in
you
the-
have to put it
in
on
the
record,
report.
sir.
Yes, my
There are.
Yes,
Why you are not filing it?
I would file it, my lord, on the next one.
You are ready to make all submissions, but you will not file it. And time and again you will take time.
No, my lord. Last occasion, I had just taken time for perusal. I had
What
got
perusal?
on the same date
Petition is
itself.
granted 2 weeks time to file exception to
Yes,
the
my
said
lord.
report. What perusal? You are perusing the report. When will the perusal over?
My
After
lord, on
2
the
years?
next day, I'll submit it, my lord. I won't waste
Do
this.
you even see
honorable-
the orders which have been passed by this court?
Yes, my lord. Yes.
What is the order passed by this court?
My lord, you had granted us time for
Then?
filing that. My lord, I'll comply with it on the next occasion, my lord. This is the last date I am seeking before this honorable.
And then you
I
want to
won't
make
waste.
arguments.
No, my lord. I'll go.
I'll close your right. You make arguments. We'll decide the issue.
No, my lord. My lord, I'll file it on the next occasion, particularly.
I'll impose cost. which I'm not doing it, I'll start imposing cost. Don't take the court for a ride.
No, my lord.
Learned counsel for the petitioner seeks and is granted one last opportunity to file his exception to the report filed by the KMC. Is granted 2 weeks time. One last opportunity of 2 weeks. List after vacation. Huh? What is the GA?
My lord.
What is the application?
My lord, for addition of parties. That was, I think, my lord, you had allowed us to, then you heard us on merit as added respondents. Then only you heard us our prayer for addition of parties.
Yeah, Mr. Ghosh, what is there in this
Actually, my
matter?
lord, the petitioner is not coming up before losses, my lord. Initially, he, my lord, did petitioner. Initially, my lord, he filed the application, my lord, ruling the balls.
Yes.
Thereafter, certain orders are passed, my lord. We have been taking which the order what have been passed by the court, and then my lord filed an application to be added as a party. But the deed petition is not, my lord, pursuing the case at all. Therefore, my lord, if he has, my lord, the case in the event, my lord, anything say, he intends to say something in respect of one particular building. If he has, my lord, got to something to say, he could, my lord, come up with an independent application for passing an appropriate order in his favor or with the direct direction upon us. But this is not the issue here, because the person, my lord, initially they filed a case, my lord, taking into account, my lord, several numbers of premises, unauthorized concern, this and that. Then the court, my lord, directed us to inspect and submit a report. We submitted. Then the court directed us to take actions in accordance with law. We have been taking an actions. The some of the proceeding has been initiated 408, some of 400 subsection 1. This is the going on, and he has made an application to be added as a party. Actually, to be added as a party, he must be a respondent. Therefore, nobody is here to take up the cause of the present petition. Therefore, if he makes an application independent of what is the proceeding here, he could have come with a separate writ application raising his any grievances that could be dealt with by your lordship.
Your lordship had heard us on other occasions regarding that. Now suddenly after filing the
He has
report,
not added. Possibly he is not official.
Yes,
He has
he has
added.
not been added.
Yes, they have not added.
You have not been added a party respondent.
Has not been added as a part.
your
You're not
lordship,
a party respondent. You're not the petitioner here. Who's the petitioner? Who's been
Petitioner is-
appearing?
not appearing.
He is concerned about one premise. He could come up with any petition, or separate.
Your lordship, this order also affects us because outrightly that report was wrong. We had a sanction plan. He said that we do
I
not
have
have a
not
sanction.
filed your exception, sir.
My lord, I'll file it on the next occasion. My lord, I'll not waste this precious time of this honorable court.
You have already wasted. These are all proxy
My
litigation.
lord, they had also lingered.
It's all a proxy.
They had taken a lot of time to file the report.
All proxy litigation.
File করতে 2 ঘন্টা লেগে দিয়েছে।
If your lordship looks at report, he is concerned about one premises. We have, whatever the initial thing was there, we have correct, facts have been noted in this report.
Wrong facts. Police station is wrong.
Where's your report, Mr. Ghosh?
This is the report dated 30th July 2025, last report.
Same day itself he has affirmed the report. Annexure C. my lord.
He is concerned about the one premises, if you look at page 11, item number 10. 28 Tilviola Road.
Item number, it's there till 10, which
10.
20A. 20A.
28 Tilviola Road. He is, my lord, raising an issue in respect of this particular premises. One additional story is there.
I'll give you 2 days time. You come next week. We'll finish it off before vacation.
Okay, my lord.
There's nothing in this matter. This court-wide order dated 31st July 2025 had granted 2 weeks time to file exception to the report filed by the corporation. Learned counsel for the petitioner seeks and is granted. Applicant seeks and is granted. Applicant in GA number 1 of 2025 seeks and is granted 3 days time to file his reply to the said application. List on, give it on Wednesday. Next Wednesday, we'll finish it off. Nothing in this matter. We'll finish it, Mr. Goshan.
Your Lordship, may be pleased to record, my lord, the petitioner is not coming to the
Learned counsel for the respondent, Mr. Ghosh says that the petitioner is not appearing in the present writ petition and the is not appearing in the present writ petition. He further states that periodic action is being taken as far as the unauthorized, illegal unauthorized constructions are concerned on the various properties mentioned in the writ petition. Full stop. Let this matter be listed on Wednesday. Top 5, Thursday, next Thursday, na? Next Thursday, top 5 matters में रख के खत्म करो. GA will dismiss it that day. We'll decide the GA also. We have not decided the GA, we have only stated. So we have not allowed the GA.
My lord, you'll be pleased to take up the GA and the exception to in the next week.
We'll finish it off.
Okay.
I am appearing with the Kolkata Municipal Corporation.
I'm appearing on behalf of the petition, being led by Mr. Das. I'm for the petition version. Direction, Your Lordship, I have all served another.
No construction is going on.
Yes.
Lordship, in respect of the present instant application, Lordship, the petitioner filed representation and also the legal notice to the private respondent indicating that the private respondent are raising some unauthorized construction.
Who are you?
Lordship?
Who are you? Where do you stay?
Lordship, I am also one of the occupant of that building. Lordship.
Yes.
I am living on the second floor and they are living on the upper floor. Adjacent to their room, they making another construction and also installed 4 water tanks over the.
There is no construction is going on.
Decide his representation, finish it off.
And my lord, they have only basic.
Wait a minute.
Only their allegation is that there is a tank has been installed. On the head of the building.
Yes, sir, you decide his
As
representation and finish it off. Is there any?
As you Lordship.
The petitioner has preferred the present writ petition, being the petitioner has preferred the present writ petition, being aggrieved by the inaction of the respondent authorities in not taking steps for stoppage or demolition of the alleged illegal and unauthorized construction being raised on the top floor premises of building number 6B, Karim Baksh Lane, Calcutta 16, at the instance of respondent number 6. The case of the petitioner is that she is a tenant in respect of second floor, while respondent number 6 is a tenant in respect of third floor of the subject premises, comma, both under the tenancy of respondent number 5 as the landlord, full stop. It is alleged that respondent number 6 has carried out unauthorized construction on the third floor and has installed additional water tanks for storage purpose, comma, resulting in seepage and leakage affecting portion of the petitioner's property. Despite repeated requests, respondent number 5, comma, being the landlord, comma, has not taken any action. Petitioner states that he has submitted a representation dated 18/3/2024 before the Director General Building, comma, Calcutta Municipal Corporation, comma, but no action has been taken till date. Being aggrieved, the petitioner has preferred the present petition. Full stop. Learned counsel for the respondent, Calcutta Municipal Corporation, submits that the petitioner's representation dated 18/3/2024 shall be duly considered. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is considered in a time-bound manner. Full stop. In view of the above, comma, the present writ petition is disposed of with a direction to the respondent corporation to consider and dispose of petitioner's representation dated 18/3/2024 within a period of 6 weeks from the date of communication of this order, comma, in accordance with law, comma, after granting an opportunity of personal hearing to the petitioner as well as the private respondent, comma, by way of a speaking order, comma, with the above direction, full stop, sorry, comma, with the above direction, the present writ petition is disposed of. I'll be back after lunch.
my lord, this is a matter where we had, my lord, prayed that the town vending committee's, my lord, resolution that no hawkers will operate from the blacktop or the carriageway needs to be implemented. This is a decision of the town vending committee which is not being implemented, my lord, so far as the new market area is concerned. My lord, the state has submitted its report, the state as well as the KMC. My lord, may I submit the exception to the KMC's report, my lord?
Exception to the report filed by the Calcutta Municipal Corporation is taken on record. Let this matter be listed after vacation.
My lord.
At the request of the parties, let this matter be listed after vacation. November, give a date on
But later, 1 week or 2 weeks after the vacation.
18th November.
18 November.
Sorry, 18th or 18th won't be there. 27th November, sorry, 27th. 27th, no? 27th? 27th November.
I appear for the respondent.
You appear for the private response.
But who was GA1? Who was
Was a substitution application lordship in view of
But,
that whose substitution has been sought has died long before.
I appear for the petitioner in this matter, my lord.
Lordship on the last day.
Who is appearing for the petitioner?
But I appear for the petitioner in this matter, my lord.
Yes.
My lord, this is a case, my lord, your lordship had granted me time, my lord, to file an application for addition of party. Now, my lord, my difficulty is that, my lord, the petitioner is 90 years of age and, my lord, I am told he is bedridden. Therefore, he is unable to come to affirm the affidavit, my lord. If your lordship, my lord, kindly grants me some time, my lord, I have to take instructions, my lord. He has not recovered, it appears.
Learned counsel for
the issue in this case, the order of demolition has been passed and the court has affirmed contempt proceeding, court
In the appellate side.
certain modalities for execution of that order, several directions upon the police authorities. These are the orders, a series of orders in this
In the appellate side, it has been filed.
now they present
Fresh
application
petition.
once again. Because all these things had been, they moved before the division bench, they moved before the contempt of court proceedings, my lord. But these are the orders are here. He wants to file with that cannot stall the process of all the orders have been already passed by the division bench and also the single.
There is no stay operating in this application, my lord. Therefore, my lord, I am hard pressed, my lord. He is unable to come, my lord, to affirm the affidavit.
There's no stay. Just take down. Learned counsel petitioner states that the petitioner is 90 years old and is not keeping good health and thus is unable to affirm what? The writ petition, what is he affirming?
No, my lord, the application for addition of party.
Affirm the application for addition of parties. Full stop. He seeks and is granted further 4 weeks time to take necessary steps. List after vacation. 18th.
I am grateful to your lordship.
20th of November.
I am grateful.
20th of November.
Item number 11. I appear for the petitioner, your lordship.
Hey, Manoj.
Lordship, reply is ready with us. It will be filed in course of the day, your lordship.
Reply has not been filed.
Reply will be filed in course of the day, your lordship.
You're filing the exception.
Lordship, no, the exception is not required against only the opposition. We are filing a reply.
You are appearing for whom?
For the petitioner, your lordship. Partha Sarathy, item number 11, your lordship.
The order records that you'll file your exception. Reply to the affidavit in opposition.
Your Lordship, that will be filed in course of the day. We are having it affirmed, it will be filed in course of the day, Your Lordship.
Course of the day.
To the opposition, the reply in to the opposition, Your Lordship.
Learned counsel for the petitioner states that he shall be filing his reply to the affidavit in opposition filed by the.
We have already filed opposition, my lord, both the parties, corporation as well as the private respondent.
You are filing for both.
Only for the private respondent, Your Lordship. For the corporation, there is no need. But I need to point out one thing: the copy given to me by the corporation of
Sir, whether you want to file it or not, I have to record it.
No, we are not filing.
Learned counsel for the petitioner states that he does not wish to file any exception to the report filed by the Calcutta Municipal Corporation. Full stop. He states that he'll be filing his reply to the affidavit in opposition filed by the private respondent during the course of the day. Let this matter be, at the request of the parties, let this matter be adjourned to. Give a date.
I'm grateful.
13th November.
My lord, I appear for the petitioner in this matter, my lord. My lord, it's that matter, my lord. Now, my lord, the issue over here is I'll be seeking for an extension of time, my lord, for filing of my affidavit in reply. The affidavit in opposition was out of time, so my lord, I'm also out of time.
We are out of time. There's no doubt about it. Kindly extend the time to file the opposition.
And my lord, there was also a direction on me, my lord, to file an affidavit of compliance. We have, my lord, kept the demand.
Copy the.
You have paid that 8 lakhs.
Well, that's kept in the fixed deposit, and my lord, a copy of the receipt thereof had been made over to the corporation, my lord. And my lord, my affidavit of compliance, it was directed by your lordship, that had also been made ready, my lord. And my lord, we have kept the FDR, my lord, extended for a period of 6 months, my lord. So naturally, my lord, the interim order, which is to expire, my lord, sometime on 10th of October, my lord, that may also be extended for a further period of 4 weeks, my lord.
All right. Affidavit in opposition filed by the respondent, Calcutta Municipal Corporation, is taken on record. A reply to the same. Full stop. Learned counsel for the petitioner seeks in is granted further 2 weeks time to file his reply to the said affidavit in opposition filed by the Calcutta Municipal Corporation. Full stop. Affidavit of compliance filed by the petitioner is taken on record. The interim order granted earlier is extended further for a period of
period.
You will continue to comply with that
Yes.
FDR.
My lord, the FDR is there for 6 months. So the direction, my lord, was for the interim period, my lord. We have furnished and fixed deposit receipt, my lord, which is for a period, which will be valid for a period of 6 months.
Which will expire on?
My lord, sometime on 12th of January, my lord. That's what the instruction is, my lord. 12th of January, 2026.
My lord can fix it, my lord, sometimes in November, my lord, after the opening.
Yes, my lord, 12th of January, 2026.
And this 12 weeks is getting over on when?
My lord, sometime in on 10th, around 10th of October, my
You're
lord.
not taking any action.
Lord, as of now, my lord, because your lordship said that my lord
Exactly.
will decide this issue. Therefore, my lord, we have.
God will decide it this side of the vacation.
No. After the vacation.
All right. The interim order granted earlier is extended further for a period of 8 weeks on the terms and conditions mentioned in the order dated July 10, 2025. on the same terms and conditions as mentioned in the order dated July 10, 2025. List on, when do you want, Mr. Kar?
Lord, anytime, Lord, after second week of November, Lord, any day. Subject to your lordship's convenience.
13th?
13th. 13th. Much
Grateful.
it will be a lucky 13th.
My lord, I am for the petitioner, my lord. My lord, my prayer in the writ application is very innocuous, my lord. Just to supply,
Where's your reply?
my lord.
They have to file the, I know what you're asking for.
Yes, my lord. So I am not
Yes,
wasting your lordship's time, my lord. They inspected. Kindly ask them to file report, but and in terms of the report, kindly dispose of this.
I have not yet received the report.
You were supposed
They
to file it.
inspected.
I shall file report.
Last time also you have taken date.
Yes, yes, my lord, that's right. But the report which has been sent to me, addressed to me, therefore I am not filing it in the form of an affidavit, it can. No, no. না না ইন্সপেকশন করেছে এটা আমার নামে আমার কাছে পাঠিয়েছে তো এটা দেওয়া যাবে
Learned counsel for the respondent, Calcutta Municipal Corporation seeks and is granted 3 weeks time to file his report by way of an affidavit. Exception to the same if any within 1 week thereafter, list after 20th November.
immediate after reopening.
Report there.
Yeah, I appeal for the petitioner. This is for implementation of an order of demolition. Lordship was initially passed that they will take up proceedings for demolition. Lordship, thereafter, Lordship has passed 2 orders, Lordship, but till date, my lord, nothing has happened.
My lord, on the last occasion, my lord, your lordship was pleased to direct the Kolkata Municipal Corporation to submit a report. Earlier, we have submitted a report, and subsequently, your lordship was pleased to direct. Your lord, it is not yet received, my lord. Your lordship, kindly take it up on next week.
This is the next week I can vacation start. This will be the 3rd day when they will ask for the same thing.
Take down. One last and final opportunity is granted, sir. Last and final opportunity is granted to the respondent KMC to file its report by way of an affidavit within a period of 2 weeks. Exception, comma, if any, be filed within 1 week thereafter, list after 20th November.
20th November.
Yes.
Lordship.
Very well. Great.
But I appear for the
Lordship, I have the interveners. Shun Chaudhary happens to lead me in this matter. He's engaged in some other court today. May I just kindly pay for a note today on his?
But the issue is the restoration of mutation. And next Thursday is the
final day before.
penultimate day before vacation, practically.
For original.
That I bow down.
For the original site.
Where are they? Where's the senior?
Your Lordship, he's on his legs, Your Lordship, just on that ground. Majumdar is here, but Mr. Chaudhary is leading me. Clerk has informed me that it's a very peculiar circumstances I am also in, but Your
You
Lordship,
don't
if I
want
may
to do
just...
it before me, you tell me.
No, no, Lordship, we want to do it before Your Lordship. Just praying for Your Lordship's...
So far as I am concerned, Lord, I can start, Lord, because this will...
Your Lordship, Mr. Chaudhary is here.
He is here.
I am grateful to Your Lordship's charity.
Yes, Mr. Jeshnu Chaudhary.
Lord, this property, Lord, is a property, Lord, which we purchased. The petitioner had purchased, Lord, on 10th of September 2007.
Yes.
Now, Lord, immediately after purchase, Lord, the petitioner had applied to the Kolkata Municipal Corporation for mutating the name. Lord, if your Lordships kindly come to page 46, the mutation was granted. The premises number is 195 Picnic Garden Road. Your Lordships will find that at the top.
Yes.
And then, Lord, the application for mutation date is mentioned. And then, Lord, it shows that names are, Lord, recorded. Ownership.
I also have an additional party application.
Yes.
Which is appearing.
Lord, on the last occasion, your Lordship had indicated, Lord, that they filed this application, but we have also filed an objection saying that they are not a necessary party so far as this is concerned. But if your Lordship wants to hear them, there is no difficulty.
2 sentences. He wants mutation in his name. Mutation is in my name. Therefore, I am a necessary party. Whether, my lord, mutation will be given to him or not will be decided by the corporation.
We'll decide the issue.
We have no problem.
Very well.
Are you opposing his application?
But if your Lordship wants, if he wants to be heard, hear him. There is no difficulty. Because when my mutation was there, my name was removed, I was never heard. The municipality didn't hear me for removing my name and putting his name.
I'm not admitting that.
I'll just show. I was coming to that. Lord, page 46 is my mutation, which was recorded. Now, Lord, what happened was that, Lord, when I purchased the property, it was occupied by a lessee.
Yes.
Kindly see page 46, your Lordships will find.
Yes.
It says, in the middle of the paragraph, it says, with reference to the aforesaid subject, you are hereby informed that the prayer of mutation has been granted in your favor by this department on 4th October 2008. And henceforth, persons who will be treated as owners, persons liable to pay tax in respect of the premises in question.
Yes.
Now, Lord, what happened is, when I purchased this property, there was a lessee whose lease had expired, but he was still in possession. And Lord, the lessee had applied to the Thika controller post expiry of the lease to be recorded as a Thika tenant of the property. Now, Lord, under the Thika Tenancy Act, there is a concept that once the property is declared to be a Thika tenancy, the property vests in the state.
Yes.
And Lord, the tenant becomes direct tenant under the state. Now, Lord, what happened is that immediately after this mutation, Lord, there was a declaration in favor of Mr. Chaudhary's client that he is a Thika tenant. Now, this declaration we had
Went up to Supreme Court.
Up to Supreme Court. Lord, we didn't succeed before the Thika controller. We filed an application for recalling. We did not succeed. Then, Lord, we went up in appeal to the tribunal, land tribunal. We did not succeed. Came to the High Court. High Court reversed the decision, declared him as a trespasser, and Lord, against that he had gone up to Supreme Court. Now, Lord, Supreme Court, there has been several rounds of litigation. If your Lordships, Lord, initially the Supreme Court had allowed, Lord, the civil appeal. Then, Lord, in review, the order was recalled. Ultimately, Lord, the final order of the Supreme Court was passed, which is at page 114.
144.
Yes, 114. It starts.
Operative portion is
Yes, Lord. 144. Your Lordships will find that the operative portion is there.
Yes.
Where, Lord, it was held that he was not a Thika tenant, And Lord, the right to property was restored in favor of my client. That's the operative part. 100 and para 126 is 124 and 126 are the operative paragraphs. Now, Lord, once this is done, this restoration done, there was a review application, which was dismissed, Lord, which is at page 148. Review filed by my learned friend client, which was dismissed. This review is at page 148. The review was dismissed. Then, Lord, there's a curative petition, which was also dismissed at page 149. So now, Lord, comes the real issue. Lord, there is a suit filed by me for eviction, which is pending in the commercial court. Now, Lord, my learned friend's client also filed a suit for a declaration that they are tenant, they are
owners by
adverse possession. Sorry, they are in adverse possession. Now, Lord, these two suits are now tried by the commercial court because, Lord, on an application filed by us, both the suits have been transferred. Lord, in our suit, they have been asked to pay occupation charges at the rate of 18 lakh something. That they had preferred an appeal to the division bench. Division bench has sustained that order. This is the situation in which, Lord, we had applied to the municipality. Your Lordships will kindly take our application to the municipality, which is, Lord, at page 112. There were two applications. One is dated 19 June 2023. 112 is the application dated 19 June 2023, where we sought restoration of our name in the records of the municipality. And, Lord, this is followed by a second application, which is at page 151, where, Lord, we again, Lord, ask for restoration. Your Lordships will take the, Lord, first representation, 19 June 2023, paragraph 3. I think I had placed these documents. Your Lordship must have marked the paragraph. So, therefore, at the initial stage, before the directions for affidavits were taken, they had filed an intervention application. So, Lord, these are the two representations which have not been acted upon. Now, Lord, interestingly, the corporation has filed an affidavit. If your Lordships kindly, Lord, take the affidavit of the Kolkata Municipal Corporation. This is an affidavit of HON'BLE and Lahiri on 29th of July 2025. Lord, please come to page 4. Kindly see the first paragraph. Therefore, the prayers of the petitioners for recording, reinstating the name of the petitioner and for correction.
Where are you reading?
Lord, page 4 of the affidavit.
Yes.
Your Lordships kindly come to the first paragraph. It's a continuation of paragraph 4 at page 4. Therefore, the prayers of the petitioners for recording, reinstating the name of the petitioner and for correction of the description of the property as non-Thika premises is based on the judgment of the Honorable Supreme Court dated 27 July 2022. Then, Lord, kindly skip the paragraph. Kindly come to the next paragraph. In mutation proceedings, corporation is prima facie not concerned with the title. It only records the name of the person liable to pay property tax. Hence, the prayer being A2 of the writ petition cannot be granted by KMC as it is not a civil court. Then, your Lordships may kindly come to page 5. Moreover, it is the settled principles of law, as it has been reiterated by the Honorable Supreme Court as well as this Honorable Court, that mutation entries in respect of any land on the revenue records do not create or extinguish title, and the mutation entries are only maintained for fiscal purposes. And, Lord, also they say that though the Thika tenancy right of the said Kumars in respect of the premises has been clearly negated by the Supreme Court, changing the assessment records of the KMC during pendency of the title suit between the Kumars and the petitioners herein in factual background that an objection has already been submitted by and on behalf of the Kumars. And this objection, your lordships will find at the as annexure A, annexed as annexure K. Annexure K, 7th May 2025. Lord, sorry, R1. I'm sorry, on R1. This is at page just after the page 11, Lord, just after the affirmation. It seems that the corporation had issued a memo to Mr. Chaudhary's client. It says reference is your memo number such and such dated 5th May 2025. Then it says under instructions on behalf of aforesaid client, we write to you as follows. This is with reference to the caption letter. In this regard, we would like to categorically place on record that we are not aware of any such order of the Honorable Supreme Court issuing direction to Kolkata Municipal Corporation to grant mutation. We request you to produce copy of the order. In fact, 2 title suits are pending, etc. Our clients are seeking recovery of possession of mean profit pending before the learned judge commercial court, then filed by our clients against so and so for declaration of permanent injunction, also pending before the commercial court in the suit filed by our client. The conveyance dated such and such. In view of the above, we express strong objection. Correct. So, my lord, this memo of 5th of May 2025, which is the referred, my lord, in the letter of 7th May, is after the writ petition was affirmed. Now, my lord, coming back to page 5, if your lordship sees the conclusion. In fact, my lord, page 5, if your lordship kindly sees the last 3 lines of the paragraph which I was reading. In these circumstances, has your lordship got that? The answering respondents are duty bound to implement and or carry out any and every direction of this honorable court. A copy of the objection letter, etc. Now, Lord, this is the defense that the municipality has taken. Lord, there are 2 sections, Lord, which I would like to show to your lordship from the Kolkata Municipal Corporation Act. One is section 183, the other is section 192. Please come to section 183.
Yes.
Says notice of transfer. Has your lordship got that? Whenever the title of any person to any land or building is transferred, such person, if primarily liable for the payment of property tax on such land or building, and the person to whom the title is so transferred, shall within 3 months after the execution of the instrument of transfer or after its registration, if it is registered after the transfer is effected, if no instrument is executed, give notice of such transfer in writing to the municipal commissioner. In the event of death of persons primarily liable, and then let come to 5. The municipal commissioner shall, on receipt of a notice of transfer or devolution of title under the section, record such transfer or devolution in a book and also in the municipal assessment book, subject to payment of area tax, etc. Now, Lord, this was accepted, my name was accepted post-transfer, entered in the records, but it was removed subsequently because, Lord, the property vested in the state and he claimed to be the Thika tenant. And then, Lord, after the Supreme Court order, now, Lord, I am seeking a restoration of my name in the records. So, Lord, devolution of title is definitely a necessity for the purpose of mutation. The lordships will see, Lord, from the section itself. 183 starts with the section whenever the title of any person to any land or building is transferred. So, devolution of interest is one of the essential conditions of mutation. And then, Lord, also have a look at section 192, section 192. Says amendment of municipal assessment book. Notwithstanding anything contained in section 190, the municipal commissioner may at any time amend the municipal assessment book. Kindly see by inserting therein the name of any person whose name ought to be inserted, by inserting therein any land or building previously omitted together with valuation, by striking out the name of any person on any land or building not liable for payment of property tax, by increasing or decreasing the adequate reasons, etc., by making and cancelling, exempting, altering the assessment on land. Now, my lord, it's my property. I want my name to be inserted. Their name can be deleted. And clause 1 clearly says that by inserting therein the name of any person whose name ought to be inserted. And Lord 3 also, by striking out the name of a person or any land or building not liable for payment of property tax. Lord, he has been held to be a trespasser by the division bench, upheld by the Supreme Court. Lord, I want my right in respect of the property to be restored. The right I enjoyed prior to his declaration as a Tikatan. And my conveyance, your lordships will have, Lord, the page that my conveyance is at page 22 of the petition. Page 22 of the petition is my conveyance. Conveyance set aside how it is.
Adverse possession means nothing until the court declares.
Page 22 is my conveyance, the registered conveyance in my favor. And Lord, this was taken note of when my name was mutated in the municipal records. So, Lord, I am seeking an order in terms of prayers A. A2. Lord, kindly see A Roman 2
Yes.
and Roman 3. Lord, because that entry is T, that has to be Thika, that has to be removed. So A, 2 and 3. Lord, these are my submissions.
Yes. I didn't want to disturb my lord, Mr. Kaur. But I am not a party to the writ petition.
Yes.
I don't have a copy of the writ petition. Only 2 respondents, my lord, I am told they are corporation. He wants my name removed. I am on the register, my lord, in the corporation. In my absence, the writ petition has to be dismissed. It's not bad strategy to come and file an application for addition of party. But if my rights are going to be affected pursuant to an order passed by your lordship, I must be present before your lordship. That's not done. Now I have now, my lord, come forward with an application. Kindly, my lord, add me as a party and direct, my lord, service of the writ petition upon me and permit me to file an affidavit. Because I'll tell your lordship, it is not that he wanted possession, he wanted mean profit from Supreme Court. Supreme Court passed an order rejecting that and giving him liberty to go before, my lord, the trial court, the civil court. Lord, that's at page 683 of my addition of party application. Now, today, my lord, there are 2 suits.
We have to add him as the party.
Lord, your lordship can give him a hearing. He has filed an intervention application.
What will I do?
Lord, he has
an affidavit.
Lord,
there are 2 suits pending.
The writ petition merely says that restore my name.
That's right.
It's
Lord,
mutation.
in restoration, Lord, what objection can he have? Lord, his objection is that he has filed a suit. I have filed a suit.
He doesn't have, he wants my name removed. He doesn't make me a party.
Lord, by filing a suit for adverse possession, one doesn't lose title.
No, you.
Lord, he has to get
order.
Carl, why didn't you make him a party?
Because he wanted to get this order behind my back.
When my mutation I lost, Lord, nobody heard me. I was never heard. So, Lord, the procedure that he is relying on, he should have relied upon that procedure when he got his name mutated.
That's all right. That I understand that, but you should have made him a party.
Lord, add him as a party. Kindly hear the matter, Lord, next Thursday.
Please give me a copy of the writ petition. Let me file an affidavit. Corporations filed an affidavit. I'm going to.
This is the whole object.
Your fault.
This is the whole object. This is not the whole object.
Object is to show the court that this is an incorrect attempt to obtain an order behind my back.
Lord, let him show that he has a semblance of a title to the property on of which, my lord, he is holding on.
Supreme Court order is there giving him, rejecting his prayer for possession.
You have been fighting with him time and again. Definitely today you have a better case in the sense Supreme Court has already given you the authority concerned as far as this is not a
But my
case of that.
right to property has been restored by the Supreme
Absolutely,
Court.
it has
He
been-
is right. He is right.
I'm not even for a minute saying that it has not been restored. But the point is you should have added him as a party respondent.
Lord, let us, Lord, accept this, that, Lord, I have to add him as a party.
Whatever it is, today we are seeking cancellation of his name and addition of
Lord,
yours.
I am not seeking cancellation. I am seeking restoration of my
Restor-
name. My restoration,
Your restoration would mean cancellation of his name.
Lord-
So his rights, whatever rightly, wrongly, are getting affected.
Exactly.
If his rights are getting affected, then he has a right to be heard.
Lord, his rights, with deepest of respect,
You
Lord,
are
I
saying
don't
he
see how
doesn't
his
have any
rights are
right.
getting affected.
That's what you are saying. He doesn't have any right.
He has to show. Let him show a single right on the property. After the Supreme Court judgment, he has no right on the property, not a single right. Because, Lord, I had read paragraph 22.
Yes.
Lord, that judgment, your lordships may kindly, Lord, have a look.
See, Mr. Carr, if I pass an order and I reject his application, or I hear his submission and I say that he doesn't have a right since the Supreme Court has already held this, it's going to be challenged.
Lord,
Right of hearing to a party.
My experience of the litigation of this party is every matter goes to the Supreme Court. Up till now, Lord, we have been at least 6 times.
At least,
And each time
at
we
least
come
the
back
form-
successfully.
At least the formality should have been completed.
Very well. Lord, keep it next Thursday. Let them file their opposition. I will not
By next
use.
Thursday?
Yes. Add them.
By next,
Yes.
we don't even have a copy.
Well, I'll give them here and now. Here and now.
Let's finish it off.
I'll give them here and now.
Chaudhary.
Yes.
Let's not
Next
linger.
Thursday, kindly keep it. And Lord, let him file an affidavit, whatever
File an
affidavit he
affidavit,
wants.
we'll finish it next Thursday.
Next Friday, my lord, in that case.
Thursday.
Thursday. Friday won't be possible. Thursday.
Only Thursday.
Thursday.
My lord, in 4 days, my lord, I'll
It's
file
okay,
an
Mr.
affidavit.
Chaudhary, you'll file it. There's nothing much in this matter. We'll finish it. Learned counsel for the respondent, the learned counsel for the applicant in GA1 has filed an application for impleadment. Full stop. It is the case of the applicant that he is a necessary party to the presented petition since his rights are getting affected. Full stop. The petitioner has preferred the presented petition seeking restoration of his name in the record books of the municipality, in the mutation records of the municipality. Full stop. The current name recorded in the municipality is of the applicant. Full stop. Since the applicant's rights will be affected by carrying out any change or rectification or modification in the records of the corporation, it is necessary to hear the respondent as a party respondent to the present writ petition. Learned counsel for the petitioner, senior counsel for the petitioner, Mr. Joydeep Kar, has no objection to the present application being heard and the present application being allowed, full stop. In view of the reasons stated in the application and the concession made by the learned counsel for the petitioner, the present application is allowed. Learned counsel for the petitioner has handed over a copy of the entire paper book to the applicant.
May I just request? I know what your lordship wants. I won't stand in the way. Now, with me there, it will become an appellate side writ petition. I'll file my affidavit on Tuesday. Kindly take it up on Wednesday, my lord.
No?
No, 1 day before, my lord. Please.
Why should it become?
Why? For what?
Because I'm outside jurisdiction.
No, maybe.
So we'll convert it now. My lord, I'm not, your lordship said Thursday. I'm saying please take it up 1 day before that. I'm not there on Thursday. I want to do the matter, my lord. Just one request, my lord.
You're not there on Thursday.
I'm not there on Thursday. I'll do it on Wednesday so that it's done.
All right.
My lord, I'm not saying don't
Keep
take
it
it
as
up.
a. All right.
Actually, to convert Korea.
I've recorded the order. Anything
No,
else
just
to be added, Mr. Chaudhary?
No, my lord. I think, my lord, with me there, when they add my name to the cause title, since I'm outside jurisdiction, it will now, my lord, have to be converted, which your lordship can direct. It will be done here itself.
and then my lord, matter can be
It's
taken
not
up.
necessary because this is absolutely a technical situation.
Don't
Not
do it, but
necessary.
please take it up on Wednesday. I have no problem.
We'll have it on Wednesday at 2 o'clock. At
Much
2 p.m. Learned counsel for the applicant seeks and is granted 3 days time to file his reply. Let this matter be listed for hearing at 2 p.m. on
I'm
Wednesday.
grateful. But I'll still tell your lordship, though, my lord, I have no one to say anything over what Mr. Kaur says. There was that judgment of Justice Dotto when we had just joined the profession, which says one respondent outside, appellate side.
But
I have
that
no
is-
difficulty if it's original.
But I tell you, Lordship, under the 226 rules, there is a provision that if you include respondents who are outside jurisdiction of the original site, because corporation has its office here. But here, my lord, my main relief
Yeah,
is not a.
Handing
I
it
am
to-
asking for record of the corporation being corrected. So, my lord, there is.
So to make that correction,
Yes, when you make the correction, just write appellate side. That's the end of the matter.
It's not necessary
Very
because
well,
I am
we'll
not
do it
seeking
from
any
the original.
personal relief against him. I am seeking,
That's
Lord,
not the test. That's not the test. The test is one respondent outside, it's appellate side. I'll show the judgment on the next day when I do the matter.
learned counsel for the applicant states that since the applicant is outside the jurisdiction of the original side, the matter should be kept on the appellate side. Full stop. Senior counsel for the applicant, Mr. Jishnu Chaudhary, relies on a judgment.
I'll bring it on the next day.
Judgment
I
so and
remember.
so.
Lord, that's the
So and
rule.
so.
Rule is that if I'm seeking relief
Alright.
against a respondent who have impeded,
In view of the said submission, learned counsel, the parties agree that the present writ petition shall be heard on the appellate side.
Does the department carry out the necessary?
In view of the same, the department is directed to carry out the necessary modification. Let this matter be listed for hearing on Wednesday.
2 p.m.
2 p.m.
grateful, much open.
Appellate side. This is something, Mr. Chaudhary.
Yes.
This is something which is difficult for me because not being a practitioner, this appellate side, original side.
It's on business.
I had once.
Luckily, Lord, we have.
I'm taking both of you on face, sir.
Yes, but we will not.
I'll show to your lordship. There is a 226 rules. I'll show to your lordship. The judgment that my learned friend is talking about is based on that interpretation of that 226 rule.
Why have any technical?
Why have a technical issue?
No, I'm not. That's why I said that. Let's.
Finishing the
Sir,
matter.
I had item 3000 in Justice Shonji Banerjee's court, which I wanted done. So I went and mentioned and said that this judgment has come. This is original site. His lordship said, yes, I'll convert it. And he said, why are you saying this? I said, 3000 will become 22. I'll get a hearing tomorrow. His lordship said, refused.
I'm happy we'll get to hear both of you. Mr. Chaudhary has not argued. He has not opened his account here.
My lord had granted leave to file a supplementary affidavit on the last occasion.
A copy may be served upon us.
I-
I'm for the corporation, my lord.
And I'm handing over a copy.
A copy has been served just now, my lord.
Copy has been served just now.
Just
So then we'll have it next week.
go through it, my lord,
Next Thursday. Not today.
next Thursday. my lord, as you-
Learned counsel for the respondent states that he has just received the copy of the writ petition. He
No, not writ petition, my lord. Supplementary affidavit.
Supplementary,
supplementary
as was directed by this honorable.
supplementary affidavit. Oh, you have filed a supplementary affidavit.
Right.
All right. He seeks and is granted time to take instruction. Let this matter be listed on Wednesday, next Thursday.
Deeply.
I'm for the state.
Grateful, man.
That I appear for the petitioner, my lord. The Kolkata Municipal Corporation has served as the affidavit in opposition. I'm seeking 1 week extension to file the affidavit in reply.
Affidavit, take down. Affidavit in opposition filed by the Calcutta Municipal Corporation is taken on record. Learned counsel for the petitioner seeks and is granted 2 weeks time to file, seeks and is granted further time of 2 weeks to file his reply to the affidavit in opposition. List on
Grateful, Milan.
13th November.
Grateful.
He kindly looks into your lordship previous order.
14. My lord, in item number 18, I am appearing on the behalf of the plaintiff, my lord. My lord, on the last occasion, KMC has been directed to file a report, Your Honor.
By an order of August 14, 2025.
Who appears for the KMC? Yes, Mr.
Yes, I am Mr. Devnath, my lord.
Where's your affidavit?
My lord, the affidavit has not yet been ready, and I have received the copy today, my report. And it is in very.
You have to file a report by
affidavit.
affidavit.
May we have a copy of the report and come back next Thursday?
This is nothing.
Not visible properly. They have sent it.
Learned counsel for the respondent corporation is granted last opportunity to file a report in the form of an affidavit in compliance of the order dated 17th July 2025. Reply to the same if any, exception to the same if any, within 1 week thereafter. List on Mr. Bhattacharya. When do you want?
Not any time convenient to you.
After,
My lord, after vacation, it would be
After
sufficient.
so 13th November.
13th November. Yeah.
13th. Much obliged.
This is at flats.
Not heritage.
Heritage. One house
Claimed
to
heritage.
claimed heritage.
My lord, I am appearing on behalf of the petitioners. Lord, kindly seize the last order dated 31st of July. A report was called for from the corporation by way of an affidavit after conducting a fresh inspection to ascertain the nature of the illegal and unauthorized construction. At the same time, my lord, my prayer was these two buildings, my lord, those were situated in a
Is that
corner plot.
Old lady.
My lord?
Old lady construction.
No, my lord. They have unauthorizedly constructed on the road, on the, my lord.
Yes, who appears for the corporation?
And
Yes.
those were corner plots. There is specific.
Mr. Ghosh, you are appearing. What happened? Where's your report?
What about the report, my lord? Not in the affidavit, but well, I am to have a talk with my officers because possibly, my lord, lines, my lord, the report, but I should not have a consultation and then, my lord, report to be submitted after that, my lord.
Learned counsel for the respondent, Calcutta Municipal Corporation, states that he has not been able to comply with the order dated 31st July 2025. He seeks and is granted one last opportunity to file a report by way of an affidavit within a period of
Weeks after vacation.
within a period of 4 weeks, within a period of 3 weeks, in terms of the direction given by this court by the order dated 31st July 2025. Full stop. Exception the same if any within 1 week thereafter. List after 20th of November.
My lord, our prayer
13th
was
November.
grateful, my lord. Our prayer was on the date, that is 2nd September, when the inspection was called on. These private opposite parties, they created a hue and cry over the spot, and they were unable to produce any sanction plan. This is our, my lord, kindly seize that, my lord.
But that Mr. Ghosh has.
Well, as you because I had some discussion and but the report my lord, in details has not been, my lord, come to us, my lord. That will I'll find out. I had some discussion with my officers.
I can't record that. Unless
All right,
until Mr. Ghosh says that that they had tried to carry out an inspection and were resisted by the private
Yes, my lord.
respondent,
Yes,
then
my
I'll
lord.
record it.
My
Yes,
lord, the inspection was held, my lord, on
My lord,
twice, my
kindly
lord, on
please
page
second and
38 of my petition. Kindly see.
Ghosh, are they resisting it?
No, no, my lord, second and fourth of
Yes, I was reported like that, but I was told, my lord, the inspection had been conducted.
My conducted, my lord, on 2nd and 4th of September.
Or let him file his report.
Grateful, my
My
lord.
lord, 13th of September. 13th of November.
Grateful, my lord.
I'm sorry, my lord, my affidavit I could not.
I am for the petition. Lord, we were also belated in filing a supplementary affidavit, so we do not. Lord, we
I'll give you time, 3 weeks. See, corporation is working. So you file it after vacation, it's okay.
Supplementary, I didn't get in time.
Yes,
They served
Lord,
it late.
we were belated in serving our supplementary affidavit on them, my lord. I will not be making any submissions on that count. My lord, may I file my supplementary affidavit with court?
Casual.
This was
Similar to that, your lordship has marked clearly, and this will also follow once the judgment is there.
You know, this involves the issue whether in liquidation sale, what will happen to the corporation's tax due, if any. So your lordship, this is on the last occasion, your lordship's view was a bit tilted, my lord. That's why we are trying to just impress upon your lordship, my lord, if possible.
Whether it is a sale under SARFAESI or it is under a self under IBC. That is not material. The material is when the notice is invited for that auction, whether that contains a clause as is where is basis.
The terms and conditions.
Yes. And the EOI contains that as is where is basis. That is the material point. Which is 3 judges bench has decided.
Here, my lord, there is one additional thing. I will not trouble your lordship today, my lord. Just one additional thing on facts. My lord, because after whatever happened, I participate, they issue the sales certificate, I get the sales certificate, I go to the corporation for mutation. My lord, what is interesting enough, that the corporation goes and files before the NCLT that my liquidator has not continued and paid me the entire amount. That gets rejected. They get a second chance at the same cherry. They again go and file before the NCLT.
See, so that is a difficulty for the corporation.
Yes.
How do they recover the money then?
Yes, my lord. So now in that event, my lord, there are a few judgments, my lord. Apart from that one Supreme Court judgment, which my learned senior friend,
are there?
my lord, I'll just tell your lordship, there is a.
Yeah, can you give it to me?
Yes, my lord. If your lordship, my lord, I don't have a copy right now, my lord. It's a national company.
Give me the write the citation.
Yes, I will just write it and
Just
give it.
write the citations, give it to me.
It's a National Company Law Appellate Tribunal's judgment, my lord. After considering Ghanshyam Mishra and the others, my lord, it was just considering whether it only applies, the clean slate principle would only apply to to going concern sales or also in liquidation. My lord, because that's the only difference. In going concern, it's a settled proposition as per Ghanshyam Mishra, paragraph 91 to 95, that everything gets extinguished. So there is no question of anything remaining. This is a judgment of 25th February 2022
of
by the
NCLT.
NCLAT, National Company Law Appellate Tribunal, my lord. But I can hand over this.
No, just give me
I'll
the
give
citation.
Lord, this is one of the judgments, my lord, which considers.
Any other judgments?
My lord, the others, my lord, there are 2 more judgments, my lord.
Give it.
I will provide.
Give the citation.
I will give all the 3 judgments.
Just give the citation.
Yes.
Back. No, because I'm going to decide this issue, so I'm on it.
Oh.
So just give me those citations also.
But my lord, just one thing, my lord. I have to be candid before your lordship. Even in this judgment, my lord, in one paragraph, if I may just place that paragraph, it considers Ghanshyam Mishra, but perhaps the NCLAT, while considering Ghanshyam Mishra and the facts of this case, also erred in coming to its finding. Because it says that Ghanshyam Mishra is very clear with regards to liquidation sale also. But in my understanding, Ghanshyam Mishra doesn't talk about liquidation sale in so many words. It was considering a situation of going concern sale. So whether, my lord, this interpretation of the Supreme Court judgment by NCLAT Delhi, my lord, that your lordship has to.
No, it has not
eventually.
considered
It has
that.
considered.
KC Ninan.
No, not KC Ninan. Ghanshyam Mishra considered. KC Ninan not considered.
KC Nina is the.
Yes. That is the one that
is holding the ground.
Yes, my lord. But in the facts, as I was saying, my lord, in the facts of this case, my lord, when the corporation accepts what has been paid by the liquidator, my lord, perhaps it would have been a different situation, my lord. In KC Nina also, a situation was where the corporation did not go before the NCLT or the liquidator My lord, when you do not go to the liquidator and there is a claim which is attached to the property as per the KMC Act, they do not take any steps. My lord, this perhaps is a situation where they approach as per law, try as per law, do not get it, my lord, there. No, my lord, then in that situation, when the liquidator paid whatever the liquidator paid, my lord, that could not have been accepted, maybe. My lord, that's the only.
My lord, we'll thrash it out.
My lord, this is the supplementary affidavit. Maybe come back one day.
Supplementary affidavit, what is there?
My lord, your lordship had passed an order for us to file supplementary affidavit annexing the sale notice and the notice inviting tender, whatever.
In the petition.
So that is why.
Supplementary affidavit filed by the petitioner. Is taken on record. Learned counsel for the respondent, Calcutta Municipal Corporation, seeks and is granted further time of 4 weeks to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List on 20th November.
A week after the vacation, I'll give him. Because it's all holidays now.
No, 20th November, we'll still
4
comply.
weeks I'm giving you, whatever it is.
1 week comes within the Puja vacation.
So, learned counsel for
Because we
the
are closing on 26th.
respondent corporation seeks and is granted 6 weeks. 6 weeks time to file his affidavit in opposition in view of the ensuing puja vacation in between. Reply to the same, if any, within 2 weeks thereafter. List on 20th November.
Great. Much of
Or 27th November. 27th.
Much of
Deeply.
Rest after lunch. If it will go on or not, we'll see it after lunch.
Great.
Deeply.
Your lordship was pleased to direct me to give notice to the other side and come back for extension of interim order in item numbers 95 to 98. Mine is 96. But in this matter, the interim order is expiring, and when the so far municipal corporation is concerned, they have used their affidavit. May I file my reply?
Who's appearing for the municipal corporation?
Lord, I
I appear for the life insurance.
Lord, I appear for the
Yes.
petitioner in item 95. Lord,
You appear for the petitioner in
95.
90.
WBO 125.
This is connected from 95 to
98, my lord, I am for the petitioner, my lord.
just
I
95 to
98. 95 to 98. 4 matters.
95, 96 and 97, I appear for the life insurance corporation of India.
Yes.
Filing my affidavit in opposition. It's already affirmed. I have.
95. Just take down petitioner appears. Affidavit in opposition is filed in
My lord,
95.
my lord, I was going to make the prayer, my lord, for extension of time to file the affidavit in reply. My lord, we have not been served with a copy of the affidavit in opposition yet.
Who's appearing in 95 and for the corporation?
For the corporation. 95.
In 95, have you served a copy? They are saying they have not received a copy.
No, he's the advocate.
You give a copy.
But
Give a
I am as per record.
95. Take down. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the affidavit in opposition. We'll give a date in November.
Instead of 2 weeks, my lord, because of the ensuing vacation, my lord, kindly keeps it 1 week after vacation then. In the meantime, I shall file it.
Is granted 2 weeks. 1 week after vacation.
I'm grateful.
So I for the 98.
After vacation. After vacation.
Yes.
My lord, I am for the
1 by 1.
1 week after vacation to file his reply to the affidavit in opposition. And just a minute, it has been served. Why are you saying it's not served?
My lord, let me have a look.
And if it is not served, how are you filing a reply?
My lord, we do not know, my lord, who Mr. P. Roy is. Who
It's all right, sir. You are seeking your reply.
Yes, my lord. I shall file the reply thereafter.
I am for life
Just-
insurance corporation in this matter.
Item 95.
I am filing my affidavit.
Affidavit in opposition filed by the respondent Life Insurance Corporation, LIC. Huh?
I have served a copy upon my lord.
My lord, I just got the copy from my learned friend, my lord. This affidavit in opposition.
Respondent number 5 is taken on record.
LIC.
Learned counsel for the petitioner seeks and is granted. Same. 1 week after vacation,
I
time
shall
to file
file the
his
reply there. At that.
reply to the affidavit in opposition of respondent number 5.
98, I am for the petitioner, my lord.
Just a minute, sir.
Interim order. My lord, that prayer, my lord, that
95 is over. 95 is over.
interim order earlier passed may be extended, my lord.
Interim order in all the matters will be extended. Interim order granted earlier is extended further for a period of 8 weeks.
8 weeks to them.
Or until for
No.
95 is first.
Ah.
95. 96. Yes, well, who's in 96?
96, my lord, I am for the petitioner. My lord, I am for the petitioner. I have filed my reply. Corporation has used the affidavit.
Yes, you have filed your affidavit in opposition. A reply to the affidavit in opposition filed by the petitioner files his reply to the affidavit in opposition of respondent corporation. The same is taken on record.
Life insurance corporation filing my
Affidavit in opposition filed by respondent number 5. Respondent number 5, right? Respondent number 7. Respondent number 7, Life Insurance Corporation is taken on record. Learned counsel for the petitioner.
But time to file.
7 in this 7. In item 95 is 5. In item 96 is 7.
Yes.
Yes, sir.
Madam, it's respondent number 7.
7. I stand corrected.
Record. Learned counsel for petitioner seeks and is granted 2 weeks time to file his
Or 1 week after vacation. My lord.
1 week after vacation. 1 week after vacation to file his
And
affidavit in reply. Or वो extension है ना?
Interim order maybe.
Interim order same.
Deeply obliged.
97 now.
My lord, I am for the Kolkata Municipal Corporation item number 97.
गोपाल ये file में डालो. 97.
My lord, I am for the Kolkata Municipal Corporation. Filing the affidavit in opposition. Get a copy.
97 affidavit in opposition filed by respondent number 5. LIC is taken on record.
95
Who's for the petitioner?
95
97 who's for the petitioner? Reply to the same if any within why same 1 week after vacation. Interim order to continue. Affidavit of
I have filed on the last occasion, your lord.
You have already filed?
Yes, my lord.
all right.
And the respondent number 5.
97 okay. 98 yes.
I am for the petitioner, my lord. I have prepared, my lord, reply, my lord. 2 sets of reply against the corporation, life insurance corporation, and one is KMC, my lord. But my lord, unfortunately, today I am not in the position to file the reply.
Learned counsel for the respondent. 1 week, I'll give you 1 week.
Yes.
Learned counsel, the petitioner seeks 1 week time to file his reply to the affidavit in opposition filed by the KMC as well as affidavit in opposition filed by the Life Insurance Corporation. Interim order extended. Give the same date. Date same. Returnable date 20th November.
20th November.
20.
20th November.
Well, this matter would require some time. Third, I was humbly submitting before Lordship, subject to Lordship's kind convenience. My lord, would your Lordship keep this matter on 6th of November so that the hearing may be continued?
Or
6th November, that's a Thursday. The first Thursday after reopening is a holiday. So, my lord, subject to your Lordship's convenience, obviously. My lord, only one humble prayer before your Lordship. My lord, I have already spoken to Mr. Kaur. Your Lordship has heard the matter on several occasions.
Partnered.
Yes, my lord.
Partnered. My lord, we are all, my lord, the parties, my lord, they in parties, my lord, do not have any objection to that. This is where we agree. This is where we agree. This is where we agree, my lord. This is where, kindly, my lord, this is where we agree. Your Lordship, has
362, I am filing the affidavit, my lord.
Mr. Kaur.
I have spoken to Mr. Kaur. Mr. Kaur also told me that make that prayer. Kindly, my lord, subject to your Lordship.
Triggered to identify 362, I am filing.
Then your Lordship may keep it on any day, subject to your Lordship's convenience. We come back to your Lordship. That's all. That's the only prayer. Joint prayer, my lord, joint prayers. Parties, my lord, your Lordship will seldom find a situation where parties are ad idem. Kindly make it part in part. Kind. Ektu daran.
Affidavit on behalf of?
On behalf of item number 224, I am filing the affidavit on behalf of the state mine.
State, very well.
362.
You don't want to file a reply or anything to this. State has nothing to do with it.
Why this is a question of law, my lord. We will answer to that.
Affidavit filed by the state. Affidavit in opposition filed by respondent number 7. The state is taken on record. Learned counsel for the. This is an item number
5 and 6.
Separate.
5 and 6.
You have filed in 5.
362.
Item 5 is taken on record. Learned counsel for the petitioner does not wish to file any reply to the same. Let these matters be listed for hearing on 6th of November. Don't make me.
No, my lord, kindly. My lord. The part is a joint prayer. Joint spare.
Spoken to Mr. Ghosh.
Mr. Kaur, my lord, he has consented to that, and in fact, he was here, but one of his matters has been called on, so he has to leave. Kindly, my lord.
Since this court has heard the matter substantially and the parties have requested the matter to be heard by this bench, let this matter be, since all the parties have requested.
Yes, all the
Shall
parties.
be heard by this bench. Let this matter be treated as part heard.
Grateful. Any date now, my lord, we will come back to your lordship. Grateful.
6th. Both the matter, 5 and 6. 6th November, both the matters.
Both the matters.
I'm grateful, madam.
At 2.
2 p.m. বলে দিন। চয়ন আছে।
Sorry, sir.
চয়ন কোথায় গেল? আমাদের এন্ট্রি মডেল কবে? তার মানে
September. I'm holding.
চয়ন আছে না? 10th চয়ন আছে না?
No, on the 6th November of the.
ও আচ্ছা পিপি সাপ্লাইস।
PP supply Nico House.
পেয়ে গেছি। This matter, my lord, rests, my lord, on a very short compass, my lord. There is a building called Nico House, my lord, in which there are 7 floors. I am the owner of a flat on the 7th floor, an office space on the 7th floor, which I have purchased from the liquidator who was appointed in company liquidation proceedings, Qua Nico House. Now, my lord, after I purchased from Nico Corporation, I have been, my lord, carrying on business there. At the instance of a complainant who is also a part occupier of a portion of the building, certain proceedings were initiated by the Kolkata Municipal Corporation under section 400 subsection 1 of the KMC Act. Now, in those proceedings, the allegation of the complainant was that apart from the first 3 floors, the upper floors are all unauthorized. Now, these proceedings, my lord, subject to, then there were orders made by this honorable court where the matter was ultimately relegated, my lord, to the municipal commissioner. His delegate, the special officer, for hearing. Special officer, my lord, was in the midst of hearing, and as the records would suggest, when I place them before your lordship, the special officer, my lord, was in the process of collecting material from the corporation's department itself, including a structural stability certificate and various plans which were lying in various parts of the corporation. My lord, the borough, etc. Now, my lord, the special officer had called for them. Now, therefore, the proceeding is at large still under 400 subsection 1. Suddenly, my lord, by an interim order made in that proceeding, keeping the remaining proceeding alive, there has been an order of demolition.
Come back again. What happened?
By an interim order made in that, special officer is hearing the proceeding, everything has come.
Yes.
I mean, he's called for a few records. He's called for a structural stability certificate. They are at large. They are about to come. Proceeding is, my lord, has not reached finality. It's pending. In the meantime, by the impugned interim order, my flat is directed to be demolished. I have a remedy of appeal. But at that point of time, because I had received this in terms of a threat of demolition, which came by a notice, I had to rush before this honorable court. I was protected. Thereafter, my lord, we've served copies. Mr. Ghosh has also come. On the previous occasion, my lord, I had made submissions that I am ready and willing to go to the municipal building tribunal if the limited order of stay granted here is extended for a short period, within which I can go and invoke the tribunal jurisdiction. It is at that point that Mr. Ghosh took the plea that whether I would be a person aggrieved within the meaning of section 400 subsection 3 of the Act in order to carry an appeal before the tribunal. And Mr. Ghosh, my lord, relied upon or threatened to rely upon certain judgments which have been passed, my lord, by this honorable court.
He had shown that judgment yesterday.
One judgment I had shown, my lord. I myself showed before your lordship, my lord.
You showed the judgment, my lord. That judgment I have not shown to your lordship. The other judgment of the division bench he showed to your lordship on the last occasion, which of course I'll be relying on that. He, my lord, showed to your lordship, my lord, and he started, my lord, certain making something on the last occasion. But the judgment, my lord, which I showed to your lordship, my lord, in that division bench judgment also relied. That is a very recent judgment. That judgment also relied in that judgment of the division bench.
So Mr. Ghosh was saying that the owner, occupier, or any person at whose instance any unauthorized construction has been
made.
And he says that what he has relied upon is that there's a very restrictive meaning which is being
By the division bench
by-
just to that expression. So it's not wide, so I'm not covered by the appeal. I was tempted to accept his argument. That makes my writ maintainable. I think I'll accept his argument. As on maintainability, I'll accept his argument. Before the writ court, I can definitely come to vindicate my grievances if there's a violation of any right, including a right to property, which I perceive, my perception is enough for me to found a list. Therefore, my lord, under 300A, I have title to a property which has now been made subject matter of an order of demolition in the midst of a process of investigation on by the first forum in which documents and evidence was being collated. If in the meantime, my lord, my premises is pulled down, then, my lord, I suffer serious prejudice. That's the ground on which I have assailed this. If Mr. Ghosh says that this is unassailable before the tribunal, I may not join issue, and I might request your lordship, my lord, to consider this and dispose it of, my lord. And this consideration, if Mr. Ghosh agrees, can be done on the other side of the vacation, subject to what falls, my lordship, or we can do it here.
Subject to who Mr. Ghosh wants to trouble, me or the tribunal.
Well, I pray your lordship decide the issue. Whatever the way he makes the submission.
Yes.
Whatever way he makes the submission, well, let it be decided.
He'll be very happy, Mr. Ghosh. He wants.
I want that, Lord,
this court to
hold that the tribunal is not available.
That's right. But if your lordship wants to hear after the vacation, there will be no difficulty because
very rarely does Mr. Alok
well,
Ghosh
he
ever
is
say
enjoying,
that
let him enjoy in certain matters, my lord. I do not stop while enjoying.
You are absolutely right.
Very rarely. This is a Halley's Comet event, man. I don't know the last, I wasn't alive 72 years before, but I think it was 72 years.
I've realized in what few months on this roster, you know, it's very difficult. Mr. Ghosh will never give you an easy time. You know, so even if something is straight, he'll ensure.
Mr. Ghosh will first take a bird's eye view and say that it appears like a dot. And then next day he'll come back and say, I was on ground, I see it's a straight line. But Lord, I've learned a lot from him. I used to sit at his chambers, Lord. He will not forget those days. 1 a.m., 2 a.m., we used to sit together discussing abstract law. Hardly anything there more pleasurable than that. Lord, whatever, Lord, today I am, a large part of that goes to Mr. Ghosh. The developing the lawyer's skill of analyzing documents, trying to make out.
But he doesn't make it easy for the bench.
He doesn't make it easy for the bench. That he doesn't. The difficulty for the bench becomes when one has to record his submissions, because my lord will find
he'll complicate the easiest of the issues, and then you have to deal with it everything. And so he's not helping us at all.
And he picks up in the third sentence of the submission. First two sentences are short. The third one will be so full of meaning that it will be difficult.
That you'll be trying to find out what exactly was said.
He said, and by the time the fourth, fifth, and sixth have gone. It's a pleasure, Lord, always good. Pleasure is always.
It's always a pleasure, but makes our life difficult. At the request of the parties, let this matter be listed for hearing. Let this matter be listed on what date you want?
6th. Lucky.
2nd week of November, you can make it.
13th of November?
13. What's it?
13th November. When is the
It's expiring on the 6th. I think
interim order granted earlier is extended further for a period of 8 weeks or until further order, whichever is earlier. Yeah, I'm not, Mr. Banerjee, I'm not fixing 2 p.m. now because I don't know what will be the roster. So I don't want to fix it.
Return on that day, return on that.
Returnable.
May I make a prayer that is written?
Whichever.
Lord, would this matter, Lord, if it's your lordship kind pleasure, Lord, return as a motion in that at the bottom of the motion list so that I can get a chance so that the matter be heard before hearing. It matter appear as a court application. Court application. হ্যাঁ, ওখানেই থাকবে।
My lord, I am for the petitioner, my lord. My lord, this is an application against the order passed by the municipal authorities rejecting my application for mutation of a property, my lord. My lord, on the last occasion, my lord, point was taken by Mr. Banerjee that the Devoto Trust was made a party, but the trustees should also be made a party. So I had, my lord, pursuant to your lordship's order, sent the entire, but they have come back as insufficient address. But I will demonstrate to your lordship that this is the address which they have been using since there's been a lot of litigation. As a matter of fact, this is a third writ petition before your lordship's court, my lord. And they have been appearing as such. And my lord, as in respondent number 5, my lord, they have already received the original copy of the writ petition, my lord. And affidavit of service is on the record. So, my lord, if your lordship so pleases, my lord, to hear me on the main matter. And before the corporation, my lord, they had appeared. Before, they had also filed an earlier writ before your lordship's court, my lord, which they had described themselves as Bukoilash Devotor Estate, with the address as 49/1 Karl Marx Sharoni.
You try to serve them again, sir.
My lord, I have done so, my lord. I have done so. Those have come back, my lord. My lord, subject to your lordship's pleasure, my lord. Subject to your lordship's pleasure. There's no question of interim order because we are there. We've been paying the municipal taxes. Up-to-date taxes are all paid, my lord. My lord, subject to your lordship's pleasure. Whether my learned friend agrees or not. My lord, my lord, so far, if your lordship kindly directs affidavits to be granted, I'll again serve, and sufficient time will be given to the trust. I'm sure they've all along they've been appearing, my lord. So therefore, sufficient time may be given to them to again appear, and again I'll serve them, my lord, and so that it can be heard on affidavits, my lord.
So that is the reason I'm saying you serve them again, try to serve them again.
Yes,
We'll
my
see
lord.
after that.
I shall.
Service, my lord, at least.
Sorry?
It's not far away. An attempt to serve physically, my lord. The office is not far away.
Try to serve them once more time.
My lord, my lord, they have described themselves as, my lord, Bhukoilash Devotor Estate and Shotto Pradip Ghoshal, and it is we have served them accordingly.
Try one more time, sir. Try to
Very
serve
well.
them again. Learned counsel for the petitioner states that the service has not been able to be effected upon the respondents, the newly added respondents. On the respondents, he seeks and is granted further 2 weeks time to file his further time to effect service upon the respondents. Let this matter be listed on 6th November.
My lord, may it be because of the vacation, my lord, and they have their
November.
Durga Puja. It is
Yes.
very good.
How much time you want?
So, my lord, may I serve it by the first week of November, my lord, by the 6th of November, and may it come up on the 13th.
Praise and is granted time till the first week of November to serve upon the respondents.
May this matter come up on the 13th.
And let this matter be listed on the 13th of November.
My lord, grateful. My lord, and these affidavits, my lord, may I file for the record?
Don't file it, sir.
Very well.
Lordship had occasion to consider this matter.
Yes,
The
Mr. Singh.
Lordship will recall 412 capital A of the Corporation Act. They have declared it dangerous. They have declared it condemned. They have said appointed a demolition contractor to demolish. Then 412A order has been passed that an option is given to the owner to reconstruct. But I have applied for the sanction.
What
plan.
happened in the mediation?
Problem is, my lord,
We have not been served with any notice.
that is
to
the problem, my lord. That is what we find, my lord. We have also written. Nothing has transpired, my lord.
Nothing happened in the mediation.
No, my lord, we have not received any notice from the mediation center only.
My lord,
No.
no,
That is the
no.
difficulty, my lord. This is our communication.
Order with petition, with the writ petition.
We have communicated it to the Calcutta High
My
Court.
lord, your lordship order has not reached there or
Member
some
Secretary.
communication gap is there.
Hey, who's the कौन है? In charge mediation sir? Huh?
Unnecessary, my lord, we wasted such a lot of
You
time
wasted unnecessary time.
because of this. This is my email communication, your lordship can see.
Just show.
Enclosing the writ petition.
We have not received.
Same premises.
Who's the in charge of the mediation sir? Where's the communication that the order has been sent to the mediation sir? Manoj? Where's the communication that the order has been sent?
And I believe, my lord, we are going to mediation, my lord, the tenants are going with a broader perspective. It should not be their case that they are just simply buying the time from your lordship.
That shouldn't be the case.
So, my lord, I will be praying. Otherwise, your lordship will take up the matter. There is nothing in this matter. The building has been declared unsafe. And I am most important.
Mr. Sen, I don't have any problem taking up the matter. The difficulty is that till the time the share and these negotiations don't take place, we won't be able to move.
But under the statute, I know, my lord.
You know it better than I do.
But this is a tool of exploitation.
You know it better than I do. You have been dealing with this time and again. You know, for me,
my lord,
it is
I
still.
was submitting. If the matter is before your lordship, they will bow down to the law.
The only thing is that let them first face some bit of mediation where at least some headway is made. Because these people don't even understand what are their rights.
Actually, my lord, we are there. We make them understand. It depends on how we make them understand. We have a duty here. This is the difficulty, my lord. And mediation, your lordship knows there is no power to the mediator.
That I know. But if you have a good mediator, at least they can hammer some sense into them.
Here, my lord, I am not taking them off their property.
That will be decided.
I am rehabilitating.
That's true. That you have to do.
I have to. That's the compulsion.
That is a compulsion.
That's the compulsion. And my lord, I'm showing your lordship the sanction plan, the proposal which I've given. Every one of them
So
has been shown.
that is only a mediator can hammer that and tell them that.
Subject, my lord, to the person on this side. Otherwise, my lord, nothing will
This
filter.
is what is expected out of Mr. Das and other people here. Mr. Murari Chakravarti, you are Mr. Murari Chakravarti.
I am for the respondent number 10 and 11, Murari Chakravarti.
I am for my lord.
Well,
7, 8, 9. I am for 7, 8, 9.
What is their objection?
We have understood. We will put our terms before the mediator and he will accept or may not accept. Then the report will be submitted before the.
See, without the terms, it's not going to happen. You also know it.
But terms in the sense
We'll
of
see what
You may
terms.
not
are
agree.
talking.
You may not agree. That is your prerogative.
Anyway, this court,
You may or may not agree.
by order dated 30.
Alternative accommodation must be there.
everyone is giving an alternative accommodation. Otherwise, I can't.
How much where?
And how much where location should be there.
Everything.
Well, let us utilize this
बुलाओ
vacation
registrar
time
को,
for
registrar
this.
को क्यों नहीं भेजा है?
No, no,
Upon the
not,
notice of
Where's the registrar?
as well as why your
not
All
in
the registrar
vacation.
with no
not in the case.
Not in vacation.
তাহলে ভেঙে গুড়িয়ে দাও আর কি করা যাবে?
হ্যাঁ ভেঙে গুড়িয়ে দিই।
হ্যাঁ সেটাই ভালো।
This court-wide order dated 31st July 2025 had referred the present writ petition to the mediation cell for exploring possibilities of an amicable settlement between the parties. Full stop.
বুঝে নেওয়া জিনিস কি কোথায়
It is
ওদের কি কোনো ইমেল আইডি বা কমিউনিকেশন করে দিতে বলবেন?
it is noted that the said order
email
was not communicated
আপনাদের ডিপার্টমেন্ট থেকে ফোন করেছিল
to the mediation cell. The Registrar General original side shall file a report as to why the order was not communicated to the mediation cell. Order dated so and so, 31st July 2025, was not communicated to the mediation cell. Full stop. It is further reiterated that the order dated 31st July 2025 shall be complied with, and the matter shall be placed before the mediation cell to be marked to a senior mediator who can explore the possibilities of an amicable settlement of dispute between the parties. Let this matter be listed before this court on 20th of November. 20th November. 27th November.
27 of that.
Well, this is I'm for the petition, my lord.
Yes.
Well, in a residential building, guest house has been run without the change of user. Complaint was writ petition was filed earlier. Directed the corporation should consider. It was considered, and the order passed by the corporation is page 94. Pursuant to the order passed by the High Court, where the trade license has been cancelled. Page 95 is the operative part of the order, Lordship. Despite the order passed on 17th March 2025,
March the order term.
Oh, wait, 94. What a High Court order.
এটা পেইং গেস্ট চালাচ্ছিল দেখে দেখাচ্ছে যে আমরা চালাচ্ছি হঠাৎ শুনুন
Yes.
In violation of this order, they are still continuing without any license that has been seized.
Why you are appearing for Mr. Sen?
Well, I am for the private respondent, my lord. It is not correct that we are still carrying on, my lord. I have already applied for a homestay license. Now that application is pending.
You were running a.
I was running a paying guest accommodation.
Running the homestay.
As because now there, but they are saying that under the Corporation Act, this is also a dichotomy which needs to be solved. There is a provision under the government tourism policy for application. You can apply and run an homestay. You have to get a homestay license. Now that I was not aware. I was running it on the basis of a trade license, a paying guest accommodation. As a guest house. There was no category in the corporation to get a license for a homestay. Now, now I find under the tourism policy, there is a specific provision for homestay license. I have already applied for that homestay license. Now that is pending. The government is not taking any steps. On one hand, their policy is saying that they are promoting homestay. On the other hand, I file an application.
Yes.
They are not disposing it off. And now, my lord, on this complaint, my certificate of enlistment, your lordship will record my submission that no business is being carried on there. After my certificate of enlistment has been cancelled, I have applied for fresh.
Regarding this, the guideline of the state government, it has been considered by the coordinate bench.
Wait a minute. If they are saying that they are not running.
They are not running, then lordship.
Then we'll record it. We'll dispose it off.
Record it. I'm not.
Kindly recorded that they are not running. If they get the license, we will not stand in the way. But till that, they are not entitled to lordship because
I'm not running.
Take down. The petition, the present writ petition, is challenging the inaction of the respondent municipality not implementing the order dated 25/3/2025 passed by the licensing officer KMC, whereby the KMC had cancelled the trade license issued in favor of the private respondent and directed the private respondent to stop using the premises number 3, Moira Street, Calcutta as guest house. As a guest house. Full stop. Learned counsel, the learned counsel for the petitioner states that the private respondent was running the said premises for operating a guest house under the name of Moira Bed and Breakfast on the second, third and rooftop of the said premises. How many respondents are there? There are different guest houses running.
No, this is family dispute. Mayank Patodia and your lordship will see all the names. They are all members of a greater Patodia family. They are partition spending. They don't want me to enjoy this.
It is the case of the petitioner that the premises
As a business income
is known as Patodia House, is known as Patodia House, is owned by private respondent number 12.
Pressure for
a
the
company
partition.
incorporated under the Companies Act, full stop. The said building comprises of 2 blocks, the southern block and the 2 blocks, block and the northern block.
Lordship.
Full stop. The petitioner and his family are in occupation of 2nd, 3rd, 4th floor of the southern block. And respondent number 8 to 10 are operating a guest house under the name and style of Moira Bed and Breakfast from the 2nd, 3rd and rooftop of northern block.
First, second, third.
First, second, third or second, third? Second,
So
third
can
and
you see
rooftop.
paragraph 14 of my writ petition? Illegal guest house situated on the ground floor, first, second, third, and the rooftop, north block. Paragraph 14.
First, second, third and the rooftop. All right.
This is on the northern block, north block.
Okay, clear? Northern block. First, second, third and rooftop. Okay, first floor, second floor, third floor and rooftop of the northern block. Similarly, respondent number 11 is running a guest house under the name Private Apartment and City Center Villa on the ground and first floor of northern block.
Great floors.
Northern block.
Because there was no specified format under the Corporation Act.
I got it.
For a guest
It is
house.
the contention of the petitioner that both these guest houses are being operated illegally in violation of the municipal building regulation and zoning regulation. Full stop. Zoning regulation.
Kindly say that we have now applied for an homestay license.
Consequently, the petitioner submitted a complaint to the respondent municipality. Full stop. The municipality, however, upon receiving no response, the petitioner was constrained to file WPO 1795 of 2023 against respondent number 8 to 10 and WPO 1796 of 2023 against respondent number 11. Full stop. This court-wide order dated 11/28/2024 was pleased to dispose of both the writ petitions, granting liberty to the petitioner to raise all his grievances before the respondent municipality. Full stop. Pursuant thereto, the petitioner submitted a detailed complaint dated 28/3/2024. Full stop. After hearing all the concerned parties, the competent authority of the respondent municipality cancelled the trade licenses issued in favor of private respondent number 8 and 11 and directed them to cease using the said premises for guest house operations. Full stop. It is the submission of the learned counsel for the petitioner that despite such cancellation orders, private respondent number 8 to 10 and 11 continue to operate guest houses from the said premises. in view of such business activity, the petitioner has preferred the present writ petition for non-compliance of the order dated so and so. Now tell me, Mr.
I have applied, kindly see page 8.
No, Mr. Sen, you are appearing for respondent number?
8 to 12. 8 to 12. All the respondents.
All the respondents. All right. Then I'll record his submission and
All the private
learn it
And also,
counsel for the
kindly say that
respondent.
my online application for
I'll just-
registration of homestay is pending.
I'll just record. Learned senior counsel for the respondent number 8 to 12. Mr. Shakyo Sen appears and states that he has stopped operating from the above mentioned premises. He undertakes not to operate from the said premises. Full stop. He further states that he had already applied for a bread and breakfast
No, homestay license.
homestay license on
As per page 82, your lordship will see page 82.
27.
It is, my lord,
27th March 2024.
27 March
On
2024.
27th March 2024.
And my lord, Ministry of Tourism has already issued this certificate in our favor.
And states that the Ministry of Tourism has already issued a certificate in their favor, though no action has been taken by the respondent municipality. Full stop. He states that he will desist to operate from the said premises till adequate licenses are issued by the respondent municipality. Full stop.
Either municipality or the state government, as the case may be, because they don't know who is the authority.
This is from using this till adequate compliances are in place.
Yes.
Adequate compliances are in place. Are in place. Full stop. In view of such submission, learned counsel for the petitioner states that he does not wish to press the present writ petition and that the respondent and that the respondent shall be bound by the statement made before this court. Full stop. In view of the statement made by the counsel for the respondent, this court binds the respondent from using the said premises till necessary compliances are met with. Nothing survives in the present writ petition. In terms of the statement made by the counsel for the respondent, the present writ petition is disposed.
May I only just say, my lord, whether your lordship kindly record the certificate which has been issued on 30th.
I recorded that.
Then it's fine.
I recorded.
পারমিশন নিয়ে এসে তারপরে তো করবে
পরের প্রসিডিং এ
Sir, he is junior to me in the school. He is behaving.
Well, this is my application.
Yes.
I am appealing for the state respondent.
Your lordship directed on the previous occasion to submit the report to the KMC.
না না ওটা নেই
Explanation sort कर लिया ना?
একটা খুলে পাল্লা হয়
Yes, Mr. Dalpati.
My lord, your lordship directed on the previous occasion
Yes.
to file the report by the KMC.
Yes, who appeared, Mr. Das? What happened?
My lord, there is no new construction. If your lordship kindly take the report, prior to that, your lordship, his allegation is, if you kindly come to page 15, the premises number is 12 Madan Chatterjee Lane.
12B.
That is page 15, subject. And every, that is the illegal building is constructing 12 Madan. My lord, thereafter, my lord, your lordship kindly come to, take the trouble of, come to, my lord, page 3, paragraph 2. Unauthorized construction of a high-rise building at 12B Madan Chatterjee Lane.
Yes.
My lord, our officers went there. There is no new construction. Practically, my lord, the picture. Joshua, একটা copy দিচ্ছি। পিকচারটা কোথায় আছে? ওটা না। হ্যাঁ। দাঁড়া তোকে দিয়ে কি হবে? My lord, the picture annexed in the petition. That is page, my lord.
Yes.
Page 15, 15 page 15.
Yes.
That is premises number, I examine 19C Muktaram Babu Street. That is your lordship. From the picture, this is a old building. Actually, the petitioner herein, my lord, in all respect, my lord, that is somehow could not detect the building which is going on there.
Mr. Dalpati.
My lord, may I suggest one thing, my lord?
Yes.
Kindly depute one receiver who will report your lordship.
My lord, first.
Whether the KMC standing before this honorable court, whether they are telling lie or not.
No. I'm
even today the construction is going on.
My lord,
appoint a special.
I will pay the I will pay the cost.
I am for the I am giving an under my lord, my junior is giving an undertaking to file the a private response. Look, my first submission is this is not a public interest litigation. Look, kindly see the address of the petitioner is 13 Pachu Dhovani Goli, and the building, my lord, is a totally different area. My lord, it is the business of some person like that. They, my lord, do this. My lord, whatever construction has been made by, that is with the plan. I am holding.
You are the respondent, private respondent.
Number 8.
What is the building number? Your building address?
My lord, my building number is, my lord.
I don't need the map. I want the building number.
That from building number will have.
Will be more than whether the construction is going on or not.
Whatever has been made.
my lord, may I hand over one paper? My lord, here is my picture. My officer sent me. Here is the 12B against which the allegation is there. The petition is either 12B or 12. Both the pictures I shown you.
13B, sir.
13B.
Yes, what is the address?
Residing at 13.
Premises number.
Residing at, my lord, that is the subject.
51 Muktaram Babu.
Page 11.
This is different.
It is alada. Page.
Prayer clause.
Notice there Tamar Bari.
Up to prayer, my lord, there is prayer. What I am showing, page 3, that is 12.
Yes, sir. What is the address?
Lord, this is a different address.
My premises
is
21
Muktaram Babu Street.
Yes, I have been made a party and my complaint has been made.
The writ petition involved Madan Chatterjee Lane.
So why have you made him a party?
Because they are raising construction, so for our instruction. If they don't, then I will expunge their name. But my lord, the building earlier was 3-storied building. With the help of the KMC, my lord, now the new construction is erecting for 6 floors.
He is no way related with that property. He is not even adjacent holder. He is not a neighbor, my lord. This is
All I take down the petitioner in the present writ petition is challenging the unauthorized construction carried out at premises number 12B, Madan Chatterjee Lane, ward number 41 under Borough 5, KMC, PS, Girish Park, Calcutta. At the
one
instance of
indulgence,
private respondent.
There is no respondent number 8 for which my learned friend is appearing. Are 7 last. My lord, there are similar matters. There are similar matters from item number 72 to 78.
Yes.
Perhaps you are appearing on that matter.
Sir, I think
426. 426 case number is 426. I am appealing for this matter.
Only 7 জন আছে দিদি.
Madam, there are only 7 people.
Yes.
As respondent. There's no respondent number 8.
But sub copy upon us the message.
এটা কত? কোন?
মেসাজ মহালক্ষ্মী
আরে
নির্মাণ
রিট পিটিশন নাম্বার।
পিটিশন নাম্বার দেখুন 426 426 my lord. My lord, kindly see this, my lord, not
24.
What has he done?
Anomaly, my lord.
Mr.
That's
Dalpati,
anomaly.
ask your briefing counsel, what has he done?
My lord, this is my lord.
Given wrong.
Motive is my your lords, you can understand.
What has he
What
done?
is
My lord, I
the
am
behind?
loaded 2 to 7. এটা 8 তো।
Other
দেখুন
6
না।
matter regarding Rajiv Sinha is in your lordship.
দেখুন আপনারা দিয়েছেন তো।
6 matter, 6 more matter. That's why that is conflict.
69, my lord.
Sorry?
69 from 6. 69.
Motive is
69.
Rajiv Sinha.
Six matters, 16 into 75.
6 matters, yes, fine.
Yes,
My lord, I got the dispute.
same person, filing 6 or
Lord,
7.
there are another 6 matters from
Yes.
item number 72
My
to
lord.
78.
Hey,
Lord, perhaps the case number is put wrongly
Yes.
because this matter was affirmed on.
Now I have to see this. Who
Social
are,
reformer, I suppose, my lord.
who are you? Why are you
He is a
filing this
social
petition?
reformer.
You file an affidavit, Mr.
Yes.
Dalpati.
My lord,
Don't appear for juniors who uses these kind of tricks and tactics to malign your reputation.
no, my lord, I am
You
sorry.
are an officer of the court, Mr. Dalpati.
My lord, my
And
57 আপনাদের case.
you should
657.
my lord, that will be 657. I am coming to your lordship's question, my
please
lord.
see
Yes.
who is this gentleman. I'm giving a date. I'm not passing any order. Please sit down with your briefing counsel.
Yes.
Boss.
Please find out why is he filing these cases.
Yes, my lord. We will ask case.
It smells some rat.
Yes.
It doesn't look very encouraging for the court.
Yes.
Since you are here,
My lord, I will satisfy your lordship.
Mr. Dalpati, if you want to satisfy me today, you can satisfy me today. But then I am telling you, I will pass adverse orders.
Yes.
I'll ensure that this particular petitioner goes to jail.
Enlarging the
If he's
list.
filing these kind of cases, time and again, 7, 8, 10 of cases, without or by being motivated, then we will get into the depth of it and find out why he's filing these cases.
That should be. That should be. I am with the court always.
So that is why I am telling you, please speak with your briefing counsel. Find out what is the reason. Use your good offices to have a word with him. Tell him, as a young counsel, even if he is doing it, he should resist not from doing this.
My lord.
At the request of the parties, let this matter be listed in after vacation. Don't allow your good offices to be used.
আচ্ছা এইটা কিন্তু 500
তাহলে আমরা কি করে জানবো
No, sorry, my lord. I got one day. That will be 5 to 6.
But Mr. Dalpati,
That-
do a
Yes, my lord.
Please
I
find-
got your lordship's point.
please find out.
Yes.
You are only appearing in one.
I mean, you
Just find out.
আপনি আমাকে এটা correct করে
ওটা দেয়
Simply adjust. At the request of the parties, let this matter.
উইদাউট নাম্বারে কপি সার্ভ হয় নাম্বার হয় না
তাহলে এই নাম্বারটা without copy সবাই তাহলে সার্চ করে তো 10খানা ম্যাটার আছে আমি কোন
এটা সেটা এটা আপনি বলতে পারেন সেটার জন্য
Construction has been done within the periphery of sanction. All on a sudden, I made voluntary application for regularization if there are some deviations according to my conscience. When I made an application before the authorities, my learned senior brother's office, good office, they did not take any decision to regularize or take any decision rejecting my application. Sudden, I came to know the personnel came to my house and threatened me to demolish some portion. Immediately, I rushed before the Honorable Court. Before taking any decision or demolition part under 400 subsections, but take my application to be decided first for regularization. But initially, my learned senior brother took a plea unless 400 proceedings are not drawn up, then proviso clause is not applicable to your case. Before Justice Malaj, your lordship one in circuit, I had the opportunity to move before Malaj.
Interrupting my land, this may not be necessary. Although that was initially I submitted that it can be done, and I find from the official record now that this representation was made 29th of May 2025, and prior to that, I reserve my submission with regard to that whether these applications could be considered by the authority 401. But prior to that, my land is saying the actions were under 400. I find that decision was taken by the Mediation Council earlier to that order. When I'm submitting this report to your lordship, therefore, my lord, the application which is asking for, because it is, my lord, we have observed that when the authority, some persons were making another construction, having come to know that certain actions are going to be taken under 408, then immediately they come to this court. On that last occasion, my lord, the order was not with me.
Proceeding
Therefore, I asked my lord,
proceeding করে demolish করুন।
This is the order passed for regulation,
not demolition.
demolition.
408. Action was taken by 400 section 8. Copy বলো স্যার?
Never
দাঁড়াও,
copy, sir.
দাঁড়াও। Petition কবে ফাইল করেছি দেখো।
কোনো কপি সার্ভিস করেনি আমাদের। বলে দিচ্ছি।
So this order, you know, this order has been passed, 408.
Subject to correction.
No.
This is, he is saying 408 proceedings.
Yes.
Now, my lord, if your lordship takes the 408 proceedings.
You forget about that. Have you challenged
No,
this
no,
order?
we didn't get.
Then
First
challenge,
time I am getting this.
challenge the order.
My lord, subject to correction. My lord, if your lordship,
Subject to correction, sir. Challenge the order.
my lord, 1 minute. 1 minute for my satisfaction.
Yes.
Now, what happened when my lord was in season with the matter? But they went to my house, demolished certain portion of land. Not kindly sees, they cannot do this in that fashion. Why? I am prima facie illegal. If your lordship take the 408, may I read your lordship? Subject to correction. Notwithstanding anything contained in this chapter, if the mayor in council is of the opinion that the immediate action is called for. Immediate action is called for.
We all know it's an emergent provision, sir.
Yes. Now, call for in relation to a building or work being carried out. Already done. Therefore, proceedings under 400 if there is one unauthorized construction.
So challenge it. You have such a good case. You
Subject,
demolished it.
but they are making all this afterthought after filing the writ petition, as I said,
Afterthought, you
because
also
without
have-
any notice to me
Very
first.
good. So challenge all this, raise all these plea and challenge the order of 400.
Well, I got your lordship's point. But
Right.
natural justice parties I am on.
Natural justice also 408. No natural justice.
Yes. Now
They have passed an order. All
When my application is pending, my lord, I am placing the already placed the judgment.
sir, do you want me to dismiss it or you are withdrawing it? What do you want?
My lord, I have কি করবে? Subject to wait, my lord, I am.
401 proceeding initiate করে দেবেন।
My lord, I am placing the judgment of.
All right, I'll dismiss it.
My lord, let it be considered.
All right.
Let the judgment
Give
be
the judgment.
considered. Yes, my lord, I have handed over to.
Hey, which judgment?
That judgment other than place. You know, take that judgment of my lord justice.
Give the judgment
Supreme
here.
Court judgment.
Yes, yes, Supreme Court judgment. Give it here.
Yes. Well, I have given to your lordship's file.
এটাকে চ্যালেঞ্জ করে আবার রিট পিটিশন ফাইল
হ্যাঁ?
করছে 408 হবে না সেটা চ্যালেঞ্জ করে তাই রিট পিটিশন ফাইল করবে।
Because pending decision of anything.
All right, take down.
Yeah.
The petitioner has
Well,
preferred to
subject-
present its
he could
petition.
Well, may I, your lordship, without any leave, I cannot. Not
present.
place, then man, make it tomorrow. Because
Why?
without any client's
Written
instruction,
Sorry?
here and now,
Written
without client's written instruction, well, I have to challenge this, your lordship, as per your lordship's desire. Let it be
Not my
tomorrow.
desire, sir. It's not
I
my
can- I
desire.
can-
My
I have
desire is to dismiss
I
it.
have to, I have to, I have to.
You don't
Let-
challenge
well,
it. If nobody's saying.
Yes, man, give me one chance to withdraw this writ petition, challenging the same tomorrow, kindly see. Because I cannot withdraw suo motu without instruction of my client. Then it is predicament for the
রিটেন
advocate.
ইনস্ট্রাকশন ব্লড
It is required to, under the advocate. He also knows this. I cannot withdraw suo motu.
I will save you from all that. I'll dismiss it.
Then I
No
leave it.
problem. You don't need
No,
any
well, don't
instruction.
dismiss it. I have
You
to
can
challenge.
tell the client the court dismissed.
Oh, no, no, let it be. Let it be. Let it be next day. One opportunity. Lordship is
that
kind
trouble-
enough, my lord, your lordship kindly enough.
I can be kind more than this. I'll save the trouble of your client also.
Let it be.
Give this back to Mr. Ghosh.
Let it be.
Mr. Ghosh, should I keep it on record or should I keep this on record? Learned counsel, just record that. Learned counsel for the petitioner has preferred the present writ petition seeking regularization. Section 403 of the KMC Act for his premises number 8/1 Vishnu Bala Lane, PS Vadgunge, WATGUNGE, Vadgunge, Ward number 76, Calcutta.
After
Whatever.
It is the case of the petitioner that he had carried out construction in accordance with the sanction plan, that the additional illegal and unauthorized construction are minor in nature and can be regularized. Full stop. Learned counsel for the respondent, municipality has handed over a copy of the order issued under section 408, wherein demolition of the entire building, order for demolition of the entire
Not entire.
Sanction.
demolition order has been passed. Where
Yeah,
where demolition order
I have the sanction plan, not the entire field. Some deviation may be there.
demolition order has been passed. A copy of the said order has been handed over to the learned counsel for the petitioner. Learned counsel for the petitioner seeks liberty to take instruction from his client to challenge the said order and withdraw the present writ petition. He prays for a short adjournment. Let this matter be listed next week. Thursday, next Thursday. Next Thursday, we'll finish. Report is taken on record. The report filed by the learned counsel for the respondent corporation is taken up.
I'm so obliged to you, lords.
Learned counsel for the petitioner has relied upon a judgment of the Honorable Supreme Court in Vijay Biskarma versus Rajkumari Devi and others, reported as 2024 SEC Online SC 2918, to impress upon the court that during the pendency of the regulation application, no action shall be taken by the respondent corporation. Full stop. The facts of the present case are not covered by the judgment relied upon by the petitioner. The respondent corporation had already taken a decision under section 408 of the KMC Act for demolition of the unauthorized portion. Full stop. In view of the same, in view of the same, learned counsel for the petitioner has sought the above instruction, has sought for time to take the above instruction.
Yes, sir.
All right, it has been prepared. Only one line is required. You come back.
He
It will be added.
me to do the matter today.
Today, give it the file.
I tender apology for that. But
Oh, no problem.
Instruction is this.
Just add one line.
To withdraw the matter.
Withdraw the matter. Oh,
To
okay.
challenging the same.
I thought you want me to dismiss the matter.
No.
Learned counsel for the petitioner, just take down,
In view of
strike the
that,
order. Learned counsel for the petitioner seeks to withdraw the present writ petition, since a demolition order has already been passed for the aforementioned property number लिख देना, ठीक है? Full stop. Liberty is granted to file appropriate proceedings in accordance with law.
much obliged. Great.
Premises number है ना, premises number लिख देना. बस that's. हाँ भाई, बस. What cut? 13E, what did you read? No, dismissed. Seeks to withdraw. Dismissals withdrawn.
Liberty to file. Get much of this.
Yes, Mr. Chakravarti.
My lord, item number 26, my lord, is my matter. It's an old and dilapidated building.
My lord,
Maybe
before my learned senior friend starts, my lord, actually, pursuant to your lordship's order dated 7th of August 2025, 3 respondents have been added. I have received the notice in respect of respondent number 8, but respondent number 8 has died in 2007, my lord. So his
Give him the
his
details.
son has to be substituted, my lord.
better particulars may kindly be supplied.
I will-
What is more, my lord, incessant rent is there. Old dilapidated building may be collapsed at any point of time. I shall remain responsible. We are in a position, my lord, to accommodate the tenants for the new construction.
In that point, I will. I
You have to add the relevant parties, then only a order.
Well, I'll bring them. I'll bring them, my lord. His father is party, my lord. Now I'll bring them.
Learned counsel for the
respondent number added respondent number 8.
learned counsel for the added respondent number, newly added respondent number 8 states that the
Son of the respondent number.
Details.
that the
Better
respondent
particulars.
number 8 has demised and states that the sons, the legal heirs of the respondent number 8 shall be added as party respondent to the present writ proceedings. Full stop. He is directed to supply the details of the legal heirs to the counsel for the petitioner, who will take necessary steps to
Leave
implead.
may kindly be granted, my lord.
To implead.
Leave may kindly be granted to incorporate this, my lord.
That's what I'm saying.
Yes, sir.
That is
To implead the legal heirs of respondent number 8 as party respondents to the present writ proceedings. Full stop. Leave is granted. Seeks and is granted 2 weeks time to add 2 weeks after.
My lord, I'm beseeching, my lord, let it be on the next week. My lord, the house may be collapsed at any point of time.
Next week, Mr. Chakravarti, how?
My lord, there will be, my lord, 1 or 2 minutes.
They will
is required.
come, they will file this thing.
My lord, 1 or 2 minutes is required. If they are agreeable, if they are agreeable for rehabilitation and all these things, corporation, my lord, circulars are there. In the event of a old deal,
If you have let them be added.
my lord,
List on 6th of November.
deep level.
6th one? Great.
After immediately.
My lord, I am appearing for the petitioner.
Now you appear for the private respondent.
My lord, actually,
There was a report which was directed from the end of the corporation.
my lord, actually,
Corporation led by Sandeep and Banerjee Lordship. It's a report.
my lord, the learned counsel appearing for the petitioner is not available, so I am praying for a not today.
What happened?
My lord, I am for the petitioner. The learned counsel appearing is not.
Falls through, my lord. Please see the report. 36A and 36B, Shakespeare Sharoni.
Exemption, partial, commercial, from partial residential at the time.
এটাই তো আমাদের premises. 36A, 36.
They're saying no unauthorized construction is there. What? Who are you? Mr. Counsel, who are you?
My lord, I am for the petitioner.
Yes. What is your interest in the property?
My lord, actually,
Are you a neighbor? Who are you? Where are you staying?
My lord, actually, Mr. Choin Gupta is appearing. He,
Oh, acha, acha, acha. This is that.
that's why.
Who's appearing?
ঠিক আছে, ঠিক আছে।
My lord, I am praying not today on his group.
No, no, keeps it afterwards. Now, let the report, whatever it's been filed, let it be kept on record. He has circulated.
This is nothing, nor here nor there. What? Yes, read the report.
Sir, you get a copy of petition.
Some repairing work found going on. What is repairing?
It is not a report. I am sorry, but my lord may not keep the report.
I'm not keeping.
I will
Proxy counsel so and so.
to filing specific report regarding this. এটা রিপোর্ট হয়েছে ফালতু রিপোর্ট এটা কোন রিপোর্ট তিন লাইনের একটা রিপোর্ট করে দিই
Proxy counsel so and so appears and states that the main arguing counsel, Mr.
Yes, Choyan Gupta.
Choyan Gupta is is not available, is indisposed,
No, he is, he's in.
is not available. Let this matter be listed after. He pays for a short adjournment. Let this matter be listed next week or
After vacation.
after.
Yeah, after vacation.
No, 1 week after.
Yes, one
One
week,
week after
Mr. Banerjee will not be in India. I am telling Milord, Mr. Banerjee will not be in this continent. No,
13th November.
13 November.
13 no. Wait.
28 Lordship, I beg to appear on behalf of the petitioner. One of the petitioner are the school teacher of under Kolkata Municipal Corporation. My lord, they are promoted to the higher grade after my lordship career advancement, and designation was also changed. Previously, my lord, teacher, then now my lord, assistant head teacher. Lordship will find my lord page 21.
Page 21.
21. My lord, the second line, their new designation is
Yes.
assistant head teacher Hindi. Third line, Lordship will find
Serial-
second line of the first paragraph, assistant head teacher. Third line, my lord, second paragraph, Lordship will see the promotees to the aforesaid post. Well, there must be a feeder post. Now they've got promotion. They are the promotee now, my lord. As being promotee, they got the assistant head teacher post.
Mr. Chakravarti, just wait.
Lordship.
You are showing me page 22.
22, my lord, the type copy possibly. No, my lord, 21.
21.
Annexure P2.
21 is some order.
Yes, my lord, order, office order.
Office order.
That is what?
Yes, you are showing that. Yes.
My lord, kindly see second line.
Second line.
Promoted to the post of assistant head teacher. So they were appointed in the feeder post, thereafter promotion got. Now, my lord, their scale of pay will be, my lord, 3,600, my lord, third line of the first paragraph. Lordship will find.
Promoted to the post of assistant
Assistant teacher.
Hindi Education Department, pay band 3, 7,100 to 37,600.
Yes, my lord.
Pay grade 3,600.
Yes, my lord. That being the situation.
All right.
Now,
then what happened?
Then, my lord, what happened since they got the promotion?
Yes.
And thereafter, the government of West Bengal, my lord, amended the provision of pay structure of the teacher, those who are in the feeder post. That is page 25A.
So there are two modes of recruitment, feeder post and...
Yes, and equal. Now it became equal. My lord, the Kolkata Municipal Corporation accepted the notification of the state of West Bengal and allowed people to join under the scale, my lord, 3,600. And we are also, as being holding the promoted post, my lord, enjoying the same post. Our representation, my lord, before the authority, and my lord, no reaction on behalf of the authority. This is one aspect. And the other aspect is, my lord, previously, my lord, there was a provision after completion of training, my lord, the scale of pay will be enhanced. That is page 35 of the teacher. Now, my lord, the Kolkata Municipal Corporation very recently is of the opinion, these particular benefits, they are going to snatch it, take it away from the teacher. This is the 2 point, my lord, we are aggrieved and dissatisfied. We wrote up to the appropriate authority for redressal. Appropriate authority, my lord, they are not caring, my lord, so far the education part is concerned. My lord, they are, my lord, concentrating in the other parts, as a result of which we are before this honorable court, the intervention of this honorable court.
Yes, Mr. Ghosh should.
So far as his primary grievance that he made a representation, that has not been taken into consideration. So far that may be allowed. I have an objection because that otherwise, my lord, it is to be hard on affidavit because of the reasons that he is primarily relying on a state government, my lord, the order. You also knows, my lord, the state government order regarding benefit to its employees, not always, my lord, giving to the our employees.
It can't be adopted. It can't be adopted always.
Here they have accepted. We know the person who are enjoying, who are in the feeder post, they are enjoying this scale of pay. Knowing fully well, we are before this honorable court.
But that is not so, my lord. Therefore, my lord, if you want, my lord, that application may be considered and disposed of.
My lord, kindly decide this matter before this honorable, from this honorable court. My lord, representation will not serve the purpose.
Right. So I'll ask them to file their affidavit.
Yes, my lord. Yes, my lord. Yes, my lord. We are in favor of affidavit.
The petitioner has preferred the present writ petition seeking a direction upon the respondent to grant enhanced grade pay slash scale of pay slash payback and arrears with effect from 1/8/2019 to assistant head teachers of primary schools run by the Calcutta Municipal Corporation. Full stop. The petitioner further prays for grant of benefit of the next higher pay scale upon completion of 5 years from service. 5 years of service from the date of publication of the result of the teachers training course, comma, which became due on 5/9/2022, comma, along with accrued arrears. Full stop. The petitioner also seeks cancellation or rescission of circular number CMF and A circular 14 of 2022-23 dated 3/11/2022. It is the case of the petitioner that the concerned individuals were initially appointed as teachers and were subsequently promoted to the post of assistant head teacher under KMC run primary schools, drawing a grade pay of 3,600 with a pay band of 7,100 to 37,600 to 37,600. Full stop. It is submitted that by a notification dated 26/7/2019, the government of West Bengal enhanced the pay grade of teachers to rupees 3,600 with a corresponding pay band. Subsequently, a resolution dated 21/1/2022. Subsequently, by a resolution dated 21/2022, the Calcutta Municipal Corporation adopted the enhanced pay grade of 3,600 for teachers of KMC run primary schools. Full stop. However, the said resolution has resulted in an anomaly where both teachers and assistant head teachers are placed in the same pay scale, comma, despite promotional nature of the post of assistant head teachers. Learned counsel for the full stop. Learned counsel for the petitioner further submits that by an office order dated 27/5/2006, the respondent municipality had granted the benefit of next higher pay scale to KMC primary school teacher who had completed 5 years of service after undergoing Madhyamik level teacher training course. Undergoing the Madhyamik level teacher training course. The petitioner, full stop, the petitioner became eligible for the said benefit on 5/9/2022 and sought the same. Full stop. However, comma, their application was not accepted. Full stop. It was subsequently learned that the office order dated 3/11/2022, the respondent rescinded the earlier order dated 25/7/2006. It is his contention that they had already became eligible for the benefit of the office order dated 5/9/2022, comma, prior to its withdrawal on 3/11/2022. Full stop. Accordingly, comma, the petitioner submits that the withdrawal of the said office order cannot operate retrospectively as to deprive them of the benefit which has already accrued to them and they are entitled for it. Full stop. Hence, the petitioner states that he is entitled to the benefit of the office order dated 27/5/2006 along with all consequential reliefs. Full stop. Learned counsel for the respondent, Calcutta Municipal Corporation, seeks and is granted. Mr. Ghosh seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 10 weeks.
4 weeks after the vacation. 4 weeks after the vacation.
2 weeks seeks time to file affidavit in opposition. 2 weeks after vacation.
Deeply applied.
4 weeks after vacation. 4 weeks after vacation. Huh? Seeks and is granted 4 weeks time to file after vacation. Reply to the same, if any, within 2 weeks thereafter. List after first week December.
Deeply applied.
First week December. आप ये दे दो 4th December.
My lord, in this matter, I have to take my.
Miss so and so appears. You want to file your reply?
No affidavit.
Mr. Ghosh, is the state also required to file affidavit?
It is state.
That may be required because the state government has,
All right.
asking for the
Learned
benefit of the-
counsel for the state also, same kar dena. State also seeks and is granted 4 weeks after vacation to file reply. Affidavit in opposition, 2 weeks. reply. Same. जहाँ respondent corporation किया ना, वहीं state भी add कर. Hearing the
29 also, my lord, I beg to appear on behalf of the petition.
In 29, my lord, I would pray leave to intervene on behalf of the occupiers.
What is?
The
Occupiers have not been met. my lord.
occupiers should be made a party, my lord, here, because it is a matter, my lord.
See, my lord, kindly see page 14.
Party make
My
everybody.
lord, kindly see, my lord, page 14.
Like, kindly
see, my lord. Page 14, my lord, they have issued a notice. Kolkata Municipal Corporation, owner and occupiers. My lord, this has been termed by them, but inspection book is lying with the Kolkata Municipal Corporation.
Make them a party.
So, my lord, that details is required to be supplied. Some unauthorized document is also there. Kindly see page 15, bottom. My lord, in the inspection book, there is very clear indication. Page 15, my lord, 8, 1, 2, 3, Roman 3. This should be sent to the concerned assessor collector for initiating proceedings of recording this in IB after giving a reasonable opportunity to all concerned building, including recorded owner, if it is found that occupants of the premises are the rightful occupier. So, my lord, occupier, there must be rightful occupier. That details is required to be supplied by the Kolkata Municipal Corporation. While issuing notice, while issuing notice, they have stated occupier, broadly stated. We have no objection. We intend to occupy. Some of the unauthorized occupiers are also there.
There is a direction on him to make repairs. my lord.
There is a direction upon him to make the repair, but he wants that demolition to be required. But corporation already directed that is a dilapidated structure, it is required to repair. Already inspection has been made in the month of January, my lord.
No. My lord, kindly see 411 notice has been issued. Report is required to be filed by the corporation. 411 notice, 30 days time was
Make
given.
application, we'll see it, we'll consider the
Very well.
application.
Very well. Make an application.
Make application for adding.
At the same time, they should answer, my lord,
Hey,
notice issued by the KMC.
There are
No
suits
action taken
pending.
by them.
Everything has been
No action taken by
suppressed,
them,
my
my
lord.
lord. Page 30, page 14.
Action for repair is to be taken by the petitioner.
Not only
That I've already done.
He has made an
that
allegation
is
that
not
we
the
are
mandate of
obstructing.
the
We are
owner and
obstructing.
occupier.
Set aside them by the court.
Not today, you make applications.
Keep it up.
Not today.
My lord, kindly give.
Not today.
When it will appear any day, my lord. Next Thursday will nothing.
Thursday, my lord.
After vacation,
My
Mr.
lord.
Let it be after vacation.
Only, my lord.
Yes, my lord, after vacation.
Tension is, my lord, apprehension is it may be collapsed.
No.
Dilapidate.
What is that? Not
That report we file. That
My
report we
lord,
file.
I will bring facts, my lord. He purchased the whole property. He has a development agreement.
No bar.
কখন আসবে? Next day.
After vacation.
Not today.
Leave it after vacation, first week of reopening. At the
Great.
Mr. Chakravarti, I'm putting it after vacation.
Lots.
The order passport.
Well,
I appear for the respondents, ma'am.
My lord, order has been passed.
Yes. I'm just saying, at the request of the parties, let this matter be listed after vacation.
the interview seeks to intervene, but that may be recorded.
You file your application,
ফাইল করলেন করবেন তো
My lord, for
Sir.
other purposes, my lord.
not for other, no.
আধার পারপাস
You are not appearing for a
Client has to know that I have appeared.
client sees everything.
Chip 30, I appear on behalf of the petitioner. So I appear on behalf of the petitioner. I'm a purchaser of a shop of measuring around 500 square feet, which I've purchased in 2022. Now, Your Lordship, the KMC has issued a
Who's
demand.
appearing? You're appearing.
So I'm for the petitioner. Now, the KMC has issued a demand on me asking for taxes from 2011-12. Your Lordship will kindly take up my deed of conveyance at page 27.
Tribunal?
Your
Yeah,
Lordship,
but he has, he has challenged practically the assessment of annual valuation. If the assessment of annual valuation is a part of the challenge, then he should go before the learned tribunal.
Your Lordship,
And that order, my lord, he is not question. He is, my lord, theoretically sees the prayer letter of intimation. Letter of intimation. There is no scope to challenge the letter of intimation. Letter of intimation is nothing but the area taxes are incorporated in that, my lord. That is the intimated. But basically, it is based on the valuation decided. Therefore, my lord, he is also questioning it. I say, I look into the prayer. Letter of intimation dated such and such, and also the annual valuation, illegal enhancement of annual valuation rupees 85,840 for an area rupees such and such. Therefore, he has to challenge that valuation.
You have not challenged.
Your Lordship, kindly takes up my deed of conveyance. The property in respect of which my
That's all
learned
right, but
Lordship,
why have
kindly
not-
2 points. Lordship, the property in respect of which my learned friend's client is claiming tax was not even in existence at that point of time. It was under development. Your Lordship, I was not even the owner at that point of time because it was under development. I only purchased it on 2022. Before that, I was not, and this is a 500 square feet shop which was brought into existence after the construction was carried out. Kindly takes up page 28, Your Lordship, my deed of conveyance. The petitioner is at page 30, the last line, Akash Goel. Your Lordship will see page 31, the developers. The name of the developers is given, Bliss Developers. And Your Lordship will see at page 38, Your Lordship kindly sees the second last paragraph. There was a development agreement entered into 2013. Before that, Your Lordship, it was a old structure on such land which has been brought down. There was development work going on. This property itself came into existence sometime in 2021, and I've purchased in 2022.
Yes.
Now, Your Lordship, kindly sees the demand issued on me. I have taken possession. Kindly takes page 81. My possession is on 8th of August 2022.
Page 80?
81. 81. Your Lordship, that's my possession letter. Kindly see page 82. Your Lordship, Your Lordship will find for the quarter of 2019. Your Lordship will see the premises is owned by Krabi Ghosh, Khelad Ghosh, Memorial Trust, Lakshmi Narayan and Radhakrishnan, and the premises number being described, hut number and street name, 19 Projadulal Street. Thereafter, Your Lordship, when I purchase it, kindly takes up page 83. On 16th of August 2024, this was, Your Lordship will see now the SSC description in the SSC. 19 Projadulal Street, shop room, unit number G7, ground floor. So the premises in question, Your Lordship, was not even in existence, of which I am asked to pay tax from 2011. The property had undergone development. At that point of time, it was a vacant land.
Yes.
Today, the KMC is issuing an LOI without assessing what was the nature of the land, today it's a 500 square feet shop, of which my learned friend is claiming annual valuation from 2011 when it was not even in existence. The question goes to the jurisdiction of the matter of issuing such LOI. If the property was not there, how can my learned friends issue an LOI on that?
Yes, Mr. Ghosh.
The property is not there. I do not understand what is my learned country.
He's saying that the development agreement was entered into and then later he had bought from the developer. So at the time when you are raising the property tax values, he is not into existence. He came much later. After the development of the property.
If he comes proportionate tax, he has to pay the area taxes.
Proportionate tax.
And my lord, and secondly, my lord, I find my lord 85,540. What my learned is alleging, my lord, he has not petition is not, my lord, specifically stated what is the position is there. I find that is the valuation was decided that unit areas. Well, of course, I followed by my learned point, my lord. He takes it up. The next Thursday, I'll take out that information.
I'm being led by Mr. Park.
Next Thursday, you will also get opportunity next.
I'll only quickly indicate because next
Thursday will get a lot of time next Thursday.
Hey,
We'll let him come back with the instruction.
I'll indicate, my lord, it's section 184 that will be indicating
see
of the KMC Act, my lord.
Not today. He has already made his submissions to the
I know.
extent that, you came into the
Property was not
property
in
much
existence.
later.
Yes, my lord. There's another additional point which
So
I'll
that's
quickly
why
indicate.
Mr. Ghosh says he wants to seek instruction.
My
Let
lord,
him
we'll
come
come
back with the instruction.
We'll come back. There's one more point which before Mr. Ghosh starts, my lord, I'll quickly indicate on the next day, my lord. Or after his instructions, I'll indicate. My lord.
What?
My lord, on the point, my lord, that today the apportionment itself is wrong. Because, my lord, today, what my learned, in the facts of the case, my lord, there's a deed of conveyance by which we come in. Your lordship, my lord, kindly takes up. My lord, here we run a medicinal shop in the premises. We purchase the property for around 35 lakhs. There's a deed of conveyance where, my lord, clause 4A and 4F of the 5th schedule is very important. Where, my lord, I'll draw your lordship's attention to page 61 and 62 of the petition. It's stated there, my lord, that there are no pending dues. That's how we come in, knowing that there are no pending dues, my lord, of the KMC or any other dues. Then, my lord, 1920, there's an annual valuation of 23,330 with effect from 1st of October, my lord, 2025. There was no outstanding then. That's a given, my lord, as on 31st of March 2019. Till then, there's no outstanding. On 16th of August 2024, we come to learn suddenly that the annual valuation has been increased to 85 lakhs 840. I'll indicate that's not in accordance with the law. Thereafter, the petitioner makes a payment for 4 quarters from 24-25 at the rate of 17,550. That's what we have paid. That's the admitted figure. 30th August 2024, we come to learn that they imposed a liability for the 3rd quarter from 2011-12 till the 4th quarter of 2022-23. Again, an illegality because no details given. Here, my lord, this sums up to 1,58,000. Again, no details given how this could be done. So, my lord, we are completely in dark. So, if he's taking instruction, my lord, this also has to be clarified.
Mr. Ghosh will shed some light next time.
We'll try and answer that. Lord. I'm very deeply obliged. We'll come back with this, my lord. And I'll show 3 judgments on apportionment on this point, my lord, that it has to be explained. Otherwise, this is not legal, my lord. Very deeply obliged.
Number 31, I'm for the petition and I'm praying for not to the union. Because the learned council is not here, for that.
What is the matter?
Matter is that I am the owner of a premises at 2 Parsonage Road, your lordship. That property was purchased by me in the year 2010, your lordship. Subsequently, what has happened in the year 2017, the said property was vacated by a tenant pursuant to the decree passed by this honorable court. Thereafter, we have applied for the mutation in the before the corporation.
So you are challenging the annual valuation?
Yes, because
go before the tribunal.
Your lordship, the order which has been passed by the hearing officer,
yes,
needs to be set aside here because he has not considered the submissions which was made by.
So whatever it is, go before the tribunal. They'll set it aside. Why should we interfere in it?
Your lordship, can you make it not today? Your lordship, keep it after vacation
You-
or next week. Or
You
lordship?
took date last time also, sir.
No, this is for the first time it appeared. Your lordship. It's taken up before your lordship. Today is the first time it matter has been.
Or
taken.
next week, not today.
Well,
Next
fix
week.
it up after vacation.
We'll dismiss it. No question of 226. Let him go before the tribunal. Mr. Mukherjee, what do you say?
As your lordship pleases. Page 58, 59 detailed order is there, your
That's
lordship.
why I'm saying, let them tell.
Page 58 and 59.
Sir, I'm making it very clear.
If he has not
Go
taken
before the
into
tribunal.
consideration the submissions made by the assessee, that doesn't call for invocation of the writ jurisdiction. The
Lordship,
tribunal
will come
can
on the next week,
consider
your
that.
lordship will make submission. If your lordship so feel, your lordship will pass this. Take it up here next
It
week.
was a vacant land, new building has come up, that gives me the
Alternative
taxable event.
efficacious remedy available to you, go before the tribunal.
This is only to revive a lost right because there is a time limit within which an appeal
That's why
has
they
to
are,
be filed.
yes.
That has not been done. Now, by way of this writ petition, he wants to revive a dead right.
Lordship, I appear for the state.
My client is a co-lessee.
My lord, as for the respondent number 7, led by Mr. Arnold Dotto, is appearing virtually.
My lord, I appear for the petitioner. The petitioner is a co-lessee in respect of 41B, Brojadulal Street. 41 capital A is the adjoining plot of land on which my lord unauthorized construction is being conducted. My lord, 11th April 2025, my lord, will find our property tax details wherein my name is recorded at page 22. We will have that.
What is it?
I am only alleging on unauthorized construction. My lord. There's a building coming up directly opposite my building. There is no here, my lord, my allegation specifically is there is no side open spaces as required under the KMC building rules being left. My lord, will find.
Yes, Mr.
My lord, will-
Banerjee. Who's appearing? Mr. Anushri, Mr. Banerjee?
I'm led by Mr.
Yes.
And I have the report also.
My lord, may I just place the pictures of the property?
Just let me see what.
But this is of June. But may I submit my lord, subject to your lordship's approval? But I wanted because it's a June for month of June. My lord gives him some time. I will make a further inspection. I will file a report.
My lord, can dispose of
My
the
lord,
matter.
as per my
Proceed
instruction,
under- My lord, I made a representation. My lord, I have no discussion. I have made a representation that's not been disposed of yet. I was only saying that I leave it up to my
my lord,
lord.
as per my instruction, there has been a proper sanction as per the repairing and reconstruction.
Who are you? Private
My lord, I am
respondent?
appearing for the respondent number
All
7.
right. Do you appear before the authority concerned?
Yes, my
Where
lord.
is-
If that all leave is
May I
given,
just
I
show
will.
some the pictures of the property?
Show me the
Yes,
representation.
page 24 is my lord, the representation. The representation, my lord, the first one is appearing at page 29. The latest representation is at page 43. Page 29 is the first representation.
Page 29 is the first representation, which is the last one,
The
sir.
last one is 30th May 2025. That's at page 43.
Page 40.
এটা তো স্টপ ওয়ার্ক নোটিস দেওয়া হয়েছে হিয়ারিং কি দেবে তো স্টপ ওয়ার্ক নোটিসে কি আছে
My lord, both the representations, because what had happened was initially after our first complaint, the construction water had stopped. We apprehended perhaps statutory compliance had been made and the authorities had taken steps. Thereafter, again, once the summer vacation of this honorable court commenced, construction again commenced. Therefore, we made another representation. Both representations can be heard and disposed of, my lord. Subject to, and my lord, just one thing I want
One
to
thing
show,
has
my lord.
happened, my lord, stop work notice has been issued.
Oh, if that is the case, my lord, then 400 has to be proceeded with.
Has to be
Has to be proceeded with. Well, page
We-
20, page
No, we have already
24, as to our urgency only, page 24, if my lord kindly has once, these are the pictures. I've taken these pictures from my property, my lord will see there's a building coming up right against my property. It's damaging my walls. It's coming up right against my property. This is the urgency in the matter. If my lord can direct the authorities.
All right, take down. The petitioner in the presented petition is challenging the inaction of the respondent in not taking any steps for demolition, the alleged unauthorized construction taking place at premises number 41A, comma, Brajo Dulal Street, comma, Calcutta. At the comma, at the instance of private respondent number
7.
Seven.
private respondent number 7. Full stop. There is only one private respondent, no?
Yes, my lord.
Yes, my lord.
All right. It is the submission of the learned counsel of the petitioner that he is the immediate next door neighbor of the private respondent. Full stop. Due to the alleged unauthorized construction undertaken by the private respondent, the petitioner is being deprived of adequate sunlight and proper ventilation. Pursuant thereto, he had lodged complaints before the respondent municipality, which had temporarily halted the construction for a few days, comma, but later the construction resumed and the private respondent is carrying out the unauthorized construction. Full stop. The petitioner states that he had made several representations before the respondent authorities, but the same have not been acted upon. Full stop. He had made his last representation on 30th/5/2025. Full stop. Learned counsel for the respondent, Calcutta Municipal Corporation, Mr. Sandeepan Banerjee states that they are ready and willing to decide petitioner's representation dated 30th/5/2025 Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the same, comma, this court directs the respondent. Which respondent will decide?
Lord, it will have to
Respondent
be
number 4,
Special officer
executive
will be
engineer. Respondent number 4, right, Mr. Banerjee?
It will be 4, my lord.
Respondent number 4, my lord.
Respondent number 4.
4 and 5.
Decide petitioner's representation dated 30th 5/2025 within a period of 6 weeks from the date of communication of this order.
8 weeks, my lord. Only
8 weeks from the date of communication of this order, comma, strictly in accordance with law, comma, after affording an opportunity of personal hearing to the petitioner as well as the private respondents or any other stakeholder, comma, by way of a speaking order, full stop. With the above direction, the present writ petition is disposed of. Affidavits have not been called for. None of the content.
My lord, one more.
Please, your
indulgence,
lordship.
my lord. One more indulgence only, my lord. My lord, Mr. Banerjee has stated that there was a stop work notice issued. I do not know. I don't have a copy of the same.
My lord,
If there is such a stop work
I
notice
now
issued,
oppose, my lord.
let this be implemented.
My lord, I have kept quiet,
no
but
objection, my lord.
my lord, I should be given an opportunity to place all the documents before the
I am giving
authority.
a copy.
Because the entire construction has been made as per Rule 3, Sub Rule 2 of the West Bengal Building
Lord,
Rules.
all I am
Kolkata Municipal
saying is,
Meeting.
if a stop work notice has been issued, the same has to be implemented. That's
And let that be decided by the authority
Let that
after
be
giving an
decided. I'm not
opportunity
gonna
of hearing for
take any
both the
comment on
parties. After we place all the documents on record, thereafter the authority can
So
decide.
then I am withdrawing. I am taking back.
Give it back.
Please, your lordship.
Submit a report.
Who are you, madam?
I'm for the state, your lordship, in this.
All right. Learned counsel for एक line add कर दो भाई. Learned counsel for the state has submitted her report. The same is taken on record.
Lord, may the submission at least of Mr. Banerjee be recorded. That a stop work notice.
Let's not unnecessarily cloud the mind of the hearing officer.
Obliged. Deeply obliged.
That is on record. You know it is on record.
My lord. Obliged.
Rest of the matters tomorrow. Tomorrow. Which one is your matter?
34 item. 39.
37.
Tomorrow. Rest of the matters, Mr. Mukherjee.
Yes, my lord.
Tomorrow.
But they're all original side.
Oh, sorry. Next.
Next.
I mean tomorrow means next.
Tomorrow for original side. Original side.
Original side.
Original side.
Lordship, item number 42, there is some urgency in the matter.
So the 42. The
By the respondent.
We'll